Keti hapo. Oh. There's some other member sitting behind, eh? That's it. Hizo siti za nyuma ni za sawa. Okay. To know what is going on. If you've not scan the question, open the question. So, there is a republic called Kijani Kibichi. Claude, where are you? Would you like to give us just a background of the question? So, Majuju, Claude, I'm only doing this because you have not answered my call. This country is a big country with around 50 million people. That is the first paragraph. The second paragraph, there is another country. So there are two countries in this question. There is Kijani Kibichi. So when you hear them saying Kijani Kibichi, they are mentioning one country. And this Kijani Kibichi, tabia zake zote zinafanana na za Kenya. 15, 15. Now it's 10. A good lawyer must always have their time. It's 10, yeah. The other day we were asking the judge to say, tunataka kufanya submission. This is a very complex, serious case. There has never been like this in the world. So, the rules were like 10 pages of submission. Hakuna mastori. 10 pages. Na sasa tutabidi tufanya 10 pages. Na nyinyi pia mtafanya nini? 10 minutes. Si mnajua point zenu? Si mnajua point zenu? So tell me when you're ready. So that child ended up in this Tusaidiane state, which looks like Nairobi, and really in domestic work. Akichapwa, akispolipwa, pesa inaenda kwa bureau. Mshaisikia bureau? Mshaisikia bureau? Yes. So, wewe ni jiulize, hapo kuna child labor? Jiulize, hapo kuna human trafficking? Jiulize, hapo kuna slavery, modern slavery? Hapo, by the way, tofauti ya modern slavery na slavery ya kitambo ni nini? Okay, I think we are ready, yeah? Yes. We are ready? Okay. I think Claude you are now the boss of this thing, eh? So I introduce the judge, then you continue. Okay. So, in this court, please tell people to keep quiet or they'll be in contempt. The ones outside and the ones inside. You don't make noise in court. If you make noise in court, you're put in. Unafungiwagwa hapo hapo. So in this court, we have 3 judges, the 3-judge bench. I'll start with Irene Oginga. She spoke to you about her experiences as a person who got into child work at 13 years of age after being orphaned, recruited by a recruitment agency, that bureau. And her experiences are very, very complex. And she ended up being abused. And right now she's okay. And she's an advocate against child labor. So later on, maybe you'll be asking her, if we don't put poor children into labor, how else are we going to help her all? Actually, is it a solution to put a poor child into labor to support? So she's there. So lawyers, as you tell us what article what without making sense, she's going to give you 0, my friend. You must make sense to her situations. So we have Justice Onunga. She was my classmate at School of Law, and she's a senior prosecutor. With prosecutor, she's in charge, she's the head of the entire Kiambu County prosecution. With a high experience, previously she was in charge of Milimani, and with a lot of experience in prosecuting child trafficking cases. She knows a lot of things, and she'll be looking to hear whether you know the facts. You can pull out facts to make sense to the law. Law is useless without facts. And then we have Justice Ojiambo, who is a litigation advocate and also a lecturer at African Nazarene, with a wealth of experience, about 20 years of wealth of experience in litigation, and also has been with us in this Moot court judging and doing cases also, similar cases. Actually, he's part of the team that is working with us on a case that I told you. This case is not hypothetical. Actually, this case is real. We want you to tell us what to do with this case. Okay? So that is a bench, and I think now we are ready to start. I think, Claude, now you can direct and tell us what else to do.
So just again, let's be silent. Let's listen to the advocates pleading their cases. After that, we shall have, in the process, judges will ask questions, as is always the case, but we shall also have an opportunity where later you'll also ask questions and get clarity on what the advocates are saying. So I now officially hand over to the bailiff. Please be silent, have your phones on silent, reduce movement, and let's all be present. So.
Good afternoon. My name is Eda Ayum. I'll be your bailiff for the day. So let's kindly settle down and maintain order. Our court session begins now. On my left-hand side is team AA02, who will be our applicants for the day. On my right-hand side is team AA05, who are the respondents for the day. So I'll hand over to the respondents to begin. Oh, sorry, to the applicants.
Honorable Justices, my name is Jacob Moot, the lead counsel for the applicant. I appear with co-counsel Arani Anthony. Yes. I don't know if I will hand over to the respondent to introduce themselves, or we continue with our submissions.
Counsel, who are you appearing with?
I appear with co-counsel Arani Anthony.
And your name is?
My name is Jacob Moot.
Jacob?
Moot.
Emoit. Appearing with who?
Arani Anthony.
Arani Anthony. For the applicant?
Yes.
Okay.
Honorable Justices, I intend to use...
Could you let your counterpart introduce themselves?
Thank you.
My lords and ladies, may it please this honorable court, good afternoon. My name is Hamisi Silaha, lead counsel for the respondents in this matter, appearing with my co-counsel, Joseph Amaganga.
Honorable Justices, I intend to use a maximum of 8 minutes to submit on the preliminary issues together with the first substantive issue, and my co-counsel will use 7 minutes, the remaining 7 minutes, to submit on the second substantive issue. Honorable Justices, we are here today because a violation has been committed against a child named Guyo, a young girl whose dreams have been shattered by the cruel chains of human trafficking and child labor. Honorable Justices, the petitioner seeks not only justice for Guyo today, but a reaffirmation of the rule of law and the enforcement of the constitutional and international commitments that binds the government of Kijani Kibichi. Honorable Justices, I'll proceed to submit on the preliminary issues. On the jurisdiction of this honorable court, the applicant submits, Your Honors, that this court, pursuant to Article 165, Clause 3 of the Constitution, that this court is vested with the requisite jurisdiction to hear and determine the matters presented in this application. Your Honor, this particular petition is with regards to the violation of the Constitution, and the records from paragraph 11 to 14 will demonstrate that Guyo was assaulted, abused, subjected to inhumane working conditions, and her dignity violated contrary to Article 28 of the Constitution. And that, therefore, my Lord, Your Honor, informs our position on jurisdiction. Your Honor, on admissibility, the applicant submits that the petitioner here in Amka Africa Justice Initiative, pursuant to Article 22 of the Constitution, has the requisite standing to file this application alleging the violation of the Constitution on behalf of Guyo. Honorable Justices, if the bench has no questions, I would proceed to submit on the first substantive issue. Honorable Justices, the applicant submits that the government of Kijani Kibichi has failed in its obligation to prevent, investigate, and prosecute human trafficking cases. And under this issue, Your Honors, I intend to submit 3 limbs of argument that will demonstrate that indeed the government has abrogated its duty. The first limb of argument is with regards to the obligation of the state to prevent human trafficking. The second limb of my argument is with regards to the obligation of the state to investigate and prosecute cases of human trafficking. The third limb of my argument is with regards to the obligation of the state to protect the victims of human trafficking. On to my first limb of argument, Your Honors. Your Honor, the applicant submits that pursuant to Article 3 of the Palermo Protocol, there is a comprehensive definition for the offense of trafficking in persons, a definition that is further reaffirmed by Section 3 of our Counter-Trafficking in Persons Act. Your Honors, from this definition, there are 5 ingredients that are noticeable. The first one is the recruitment of the victims. The second one is the use of deception to abuse the victim's vulnerability. The third one is the transportation of the victims. The fourth one is the receipt and harboring of the victims. And the fifth one is the exploitations of the victim. Your Honors, from the records from paragraph 5 to 14 will demonstrate that Guyo was deceitfully recruited from Kilimobora by Sony, transported from Kilimobora to Kijani Kibichi, received by Rehema Recruitment Agency, harbored by Rukia, where ultimately the exploitation took place. Your Honor, it is a non-contested fact that indeed the victim herein went through the cruel chains of human trafficking under the watch of the respondent herein. Your Honor, allow me to turn this court's attention to the provisions of Articles 9, 10, 11 of the Palermo Protocol, which mandates the state to take comprehensive measures and policies that are geared towards preventing and combating human trafficking. Your Honor, allow me to stress on the requirements of Article 11 that mandate states to put in place border control measures that are capable of detecting and preventing human trafficking. Honorable Justices, I submit that the government herein failed to intercept Guyo's illegal transit into Kijani Kibichi despite clear indicators of trafficking such as her minor status. And that, Your Honors, demonstrates a lapse in the government's duty to enforce its border control measures effectively. Your Honor?
Counsel, are you almost?
Yes.
You have 2 minutes.
Thank you, Honor. Your Honor, allow me to quickly turn this court's attention to the case of Ransev versus Cyprus and Russia application number 2565 of 2004, where the governments of Kijani Kibichi, the case of Ransev versus Cyprus and Russia, application number 25965 of 2004. And this case was decided by the European Court of Human Rights. This case, Your Honors, is critical in reaffirming the obligations of governments to international instruments. The governments of Russia and that of Cyprus, Your Honor, were found to have failed in their obligation to establish suitable framework to combat trafficking. Your Honor, this case, I implore this court to use this case as a persuasive authority to find the government of Kijani Kibichi culpable of absconding its international duties. I notice my time is far much spent, Your Honors. I would like to guide this court to our written submissions where we have comprehensively canvassed our other limbs of argument. Your Honors, as I conclude, I hope and implore this court to uphold the best interests of a child principle when making a determination on Guyo's rights violation. I yield the floor to my co-counsel.
May it please this court. As I had been previously introduced by my co-counsel, my name is Arani Anthony, and I'll be taking the next 7 minutes to demonstrate to the court that the government of Kijani Kibichi failed in its duty to protect children's rights as guaranteed by our national laws and the international laws that it has ratified. Your Honors, before I begin my submissions, I would like to reiterate the words of my co-counsel. My co-counsel reminded the court of Article 3 of the United Nations Convention on the Rights of a Child, which mandates every public and private body, every government authority, and all the courts of the law that in all actions concerning children, the child's best interest shall be a primary consideration. And it is in light of this provision that the applicant is here today, not just as a representative of the law, but to speak for the, but to act as a voice of the voiceless and as a defender of the defenseless. Your Honor, the applicant is here today to demonstrate to the court that in all matters that regards the protection of children's rights, we shall not take it as a child's play. Your Honor, on substantive issue number 2, we intend to demonstrate our submissions in the following ways. Number 1, we will demonstrate to you that the right to education of Guyo was violated. Number 2, we will show you that Guyo's right to protection from exploitative child labor was violated. And finally, we will demonstrate to the court that Guyo's right to freedom from torture and inhumane treatment was violated. If the court seeks no clarification, I would like then to proceed to tackle my first argument. Your Honors, Article 53(1) of the Constitution of Kijani Kibichi, when read in conjunction with Section 4 of the Basic Education Act, gives every child the right to free and compulsory basic education. This right has also been reiterated by the courts in the case of Nyabola v. Attorney General. But what we have here, we have the case of a young girl who, in the hopes of earning an income in Tusaidiane, was promised that her bead work limited to 2 hours on the weekdays and 4 hours on the weekdays, which would allow her to attend school during the weekdays. But unfortunately, these promises were false. She ended up being restrained in Rukia's household. Who locked her up in a house and did not allow her to go outside so that she could attend school to further her studies. Your Honor, she was also forced to subsist mostly on leftovers that were left from the food that she was preparing the family, which is a further contravention of Article 53, which not only guarantees the right to education, but also enumerates other fundamental rights, such as the right to basic nutrition. Your Honor, I will then proceed to the second leave of my argument, where we intend to show the court that Guyo's right to protection from exploitative child labor was violated. Your Honor, the applicant would like to turn the court's attention to Section 2 of the Children's Act, which includes child employment as a form of child abuse. This has been further reinforced by the Children Employment Regulations of 2020, where in Regulation 5.2a actually classifies domestic work as activities that are detrimental to a child's health, a child's safety, and a child's mental capability. Section 18 of the same Children's Act, when read with Article 32 of the United Nations Convention on the Rights of a Child, obligates the government to prevent child labor, domestic work, economic exploitation, or any hazardous work that interferes with the child. But what do we have here? We have the case of a young girl who was forced to clean a 5-bedroom house, who was supposed to take care of 4 children, where if you look at the age gap between the eldest child and this young girl, Guyo, there's only an age gap of 2 years. She was supposed to clean the camp, to prepare the meals for the family, and to even add salt to the injury, Your Honor, she was supposed to wake up at 4:30 a.m. to prepare the children to go to school. She was supposed to sleep at 10 a.m. to prepare food for the husband who usually came home late from work. Your Honor, if these represent a clear contravention of the constitutional rights as guaranteed to this child named Guyo, then we should not be calling ourselves a country that prides itself in the protection of children's rights. Your Honor, I will then proceed to my final argument, where we will demonstrate to the court that Guyo's right to freedom from torture and inhumane treatment was violated. Your Honors, Article 25 of the Constitution of Kijani Kibichi, when read alongside Section 25 of the Children's Act and Article 37 of the United Nations of the Conventions of the Rights of a Child, mandates the government to protect every child's right to freedom from torture, cruel, or inhumane or degrading treatment. But what we have here, Your Honor, we have here a case of a young girl who was frequently subjected to verbal and physical abuse. We have a case where she was called Mjinga Wewe, which translates to "you stupid person." On May 26, 2023, she accidentally burnt a shirt belonging to one of her children. And what was the punishment? Your Honor, Rukia took a hot iron box and burned the shoulders of this child. Your Honor, I do recognize that my time is far much spent, but I would like to refer the court to our submissions. And if the court allows me, if the court has no further questions, I will then proceed on to handle the prayers of the applicant. Your Honor, it is the applicant's prayer that this honorable court be pleased to adjudge as follows. Number one, a declaration that the respondent has failed in its obligation to prevent, investigate, and prosecute the trafficking of children, to issue an order of mandamus directing the respondent, the government of Kibjankibichi, to immediately commence an investigation, and finally, to direct the respondent to offer full reparations as the court may deem fit. Your Honor, as I conclude, I would like to leave the court.
May you come again, your prayers?
The final one, or?
What prayers do you want the court to grant?
All right, I will begin. Number one, a declaration that the respondent has failed in its obligation to prevent, investigate, and prosecute trafficking of children, in this case, Guyo. Number two, that the court issues an order of mandamus directing the respondent to immediately commence a diligent investigation into the trafficking network responsible for the trafficking of Guyo. Number three, to direct the respondent to provide full reparations to Guyo. And finally, any other full reparations to Guyo, including but not limited to restitution and the rest. And finally, any other relief as the honorable court may deem just, fit, and grant. And as I conclude, I would like to leave the court with one final thought. Sounds of deceit, each quiet confirms a full feat. Every time we do not help the victim, we affirm the actions of the perpetrators. Thank you.
My Lord and ladies, once again, I am Hamisi Silaha, lead counsel for the respondent in this matter. I will proceed to take 7.5 minutes to submit on jurisdiction as admissibility as well as issue A, while my co-counsel Joseph Amaganga will take 7.5 minutes as well to submit on issue B, C, as well as the prayers sought before this honorable court, my lords and ladies. And I'd request that our time be counted separately, please. If there's no further question from the bench, I wish to proceed. Lord and ladies, indeed it is a good day. But on this good day, the respondents are very sad. The respondents are sad by this case of Guyo. We have a meeting of minds with the petitioners to say that an injustice has occurred, and we need to tender justice to this case of Guyo. But again, we are saddened even further to see that this constitution that we have fought so hard to have in Kijani Kibichi is being threatened today, my lords and ladies. For the past 15 minutes, we've watched as the applicants, my lords, built you a house, a very beautiful house. In fact, let me call it a mansion. This mansion is filled with stairs, big windows, very beautiful wallpaper. But this house, my lords and ladies, does not have a foundation. They have skipped very important processes in bringing the suit to this high court. And as we will demonstrate in our proceedings, submissions, my lord and ladies, it will become apparent that this court should not, in fact, entertain the matters before it. On to the question of jurisdiction, my lords and ladies. Jurisdiction is defined in Halsbury's Laws of England, 4th edition, as the court's authority to entertain or litigate matters before it. Justice Nyarangi told us, jurisdiction is everything, and where a court does not have jurisdiction, it has to down its tool. The Supreme Court came further and reiterated in the case of Samuel Kamau Macharia versus KCB that jurisdiction strictly flows from the Constitution and statute, and a court cannot and shall not arrogate itself jurisdiction. My lords and ladies, the applicants heavily relied on the Children's Act. Allow me to reiterate on the same. The Children's Act covers on questions of trafficking, questions of abuse, questions of employment of children, but this same Children's Act establishes the Children's Court under Section 90. This Children's Court is given jurisdiction, and this jurisdiction is also further elaborated under Section 143 of the same Act. This court has the mandate to listen to matters trafficking, matters abuse, matters employment of children, my lords and ladies. In that instance, this children's court becomes the court of first instance. We are in the High Court today. What is the role played by the High Court in this instance, my lords and ladies? The High Court becomes an appellate court. The High Court becomes a referral court. The High Court becomes a court for judicial review on the same matter. From the fact sheet, from the first page to page 6, the applicants have not presented their matters before any court or any body that has been established by the Constitution, my lords and ladies. The court, in the case of Gladys Nduku Nthuki versus Let Shego, stated, allow me to read it verbatim, where a matter falls within the jurisdiction of a specific tribunal or body established by law, it must be commenced there before the High Court. Has that been done, my lords and ladies? No. On the question of admissibility, in the case of Anthony Miano versus the AG in the High Court of Kijani Kibichi, the court stated that the question of admissibility elaborates several elements under it. The question of locus standi, we do not contest. The question of mootness, we do not contest. The question of ripeness, we do not contest. Then we come and fall on the question of doctrine of exhaustion, my lords and ladies. The court, again, in the case of William Ramogi and another versus the AG, stated that the question of exhaustion of remedy arises where the law, statute, and the Constitution establishes a remedy for an aggrieved party, but they forego that remedy and institute proceedings before a court. My lords and ladies, the 2010 Constitution establishes a process where if a person moves from a judicial body or a court established in statute, then they have to move in appeal from that body, court, subordinate court, then to the High Court, from the High Court to the Court of Appeal, from the Court of Appeal to the Supreme Court. My lords and ladies, these are not my words. I am not that wise. These are the words of Justice Renaola as he then was. My lords and ladies, the IPOA Act, the Independent Police Oversight Authority Act, establishes the IPOA. Many of the questions being raised here by the applicants are in regards to the lack of investigation by the police. This authority was established and is given a mandate under Section 9 of that Act to exercise oversight over the police. That includes to receive complaints, investigate complaints, as well as offer remedies. These remedies proceed to them issuing instructions to the ODPP to institute proceedings, ladies. That has not been done. The Supreme Court of Kibichi, in the case of Nicholas versus the Attorney General, stated that where an alternative remedy exists, court should exercise restraint. My lords and ladies, an alternative remedy exists. You ought to exercise restraint. Now, without prejudice, and in the very unlikely event, my lords and ladies, that you find that maybe you have jurisdiction, that maybe this matter is indeed admissible before this honorable court, then we urge you to accept our submissions as follows. On the first issue, as raised by the applicants, we raise the doctrine of sovereign immunity. The doctrine of sovereign immunity is captured in the common law principle, rex non potest peccare. A king can do no wrong. This doctrine has evolved over the years, and it encapsulates that governments should not be held liable for the mistakes, for the errors of individuals within the state. My lords and ladies, the suit before you, as gotten from the fact sheet, encapsulates a story of Guyo, a 13-year-old girl. Allow me to correct that fact. She was not 15 at the time of the offense happening. She was 13 years old. A 13-year-old girl trafficked from the neighboring country, Limobora, all the way to Kijani Kibichi, in the hope that perhaps she'll get a better future, a brighter future. In this same suit, we can see several people taking part in this suit, my lords and ladies. These people include Rukia. These people include Rehema Recruitment Agency. These people include the laxity of the police. The government, through the Constitution, has established several forums, several remedies that can be to address all the issues. The applicants have skipped all these established remedies and presented the matter directly to the High Court. My lords and ladies, at the international standard of liability, it has always been at the individual level. If you look at the case of the prosecutor versus Jean-Paul Akayesu, and the case of the prosecutor versus Omar al-Bashir, the courts employed individual liability, my lords and ladies. I can see my time is far much gone. I'd urge you, my lords and ladies, to stand with the Constitution of Kijani Kibichi. I'd urge you, my lords and ladies, to stand with Guyo as she seeks justice, as we seek justice, my lord and ladies. To that end, we hope that you litigate in our favor and do pray for the rains.
My lord and my ladies, I am Joseph Amaganga, as introduced earlier by my co-counsel. I rise on behalf of the respondent on this particular matter. My lord and my ladies, we seek to demonstrate before this honorable court that indeed, as the respondent, we are saddened by the situation of. We seek to demonstrate before this honorable court that indeed, as the respondent, we have done our mandate to ensure that we protect the child in the state of Kijani Kibichi from all forms of abuse. My ladies and my lord, we are going to demonstrate before this honorable court in three limbs, in terms of prevention, in terms of protection, and in terms of prosecution. My ladies and my lord, we'll begin with prevention. My ladies and my lord, as the government of Kijani Kibichi, in response to what the respondent have stated, they have stated that as the government we have done nothing, we have put nothing in place to ensure that the children are protected. My ladies and my lord, however, they went ahead to mention Article 53 of the Constitution. We have gone ahead to provide for the best interest of a child. In any matter concerning a child, Article 53 states that the rights of a child shall prevail. We found this article not to be adequate. We supplemented it with the Children Act of 2022. We went ahead to establish the Basic Education Act. My ladies and my lord, it has been before this honorable court that the government has not been doing any types of abuse. I will refer this honorable court to a judgment that was issued by Justice Lenaola, as he was then, in Githunguri Residents Association versus the Cabinet Secretary, Ministry of Education, and others. In this particular case, my ladies and my lord, it included a case, I beg to pardon, where the Githunguri residents brought an issue to court for determination that they had instituted fees, and yet the Basic Education Act had provided that students shall learn for free. As provided for under Article 50 of the Constitution, education is free. However, it is upon other agencies that work together with us to ensure that this particular aspect has been implemented. Why do we say so? The judges of the holding, who falls under the judiciary, which is an arm of the government, the definition of free should be free. And lunch programs, transport fee, which was to a cost of 12 million, was found to be in violation of these particular principles. I must say before this honorable court that the government is working to ensure that any iniquities that arise thereof are catered for. Going ahead with my question, my ladies and my lord. In 2020, 18 trafficking cases were investigated. We demonstrated before this honorable court that 11 traffickers were arrested. It is our submission before this honorable court that at least 46 individuals were prosecuted. We submit as well of June 2019, I beg to pardon, June 2020, the government had all this done within. Guyo's case has been, my lord, and under Article 258 of the Constitution, we have enabled this particular organization to bring such suits. Under Article 21, my ladies and my lord, we have established as a country, as a state, my ladies and my lord, we are going to ensure that children's rights have been protected. How are we doing so? By implementing legislation. First one to Article Minimum Age Convention. It provides every state shall implement a national policy to ensure that children's rights, to ensure that children are protected from child labor. We have the Employment Act of 2007. It distinguishes between light work and heavy work. It distinguishes between the type of work that children can be subjected to and the types of work that children cannot be subjected to. My ladies and my lord, once children have been subjected to work that is not defined under the Employment Act, then there is a penalty. This penalty is minimum. It amounts to 30 million, even 5 years imprisonment. Ladies and my lord, on assault, Section 251 of the Penal Code provides every person, every individual who shall be found liable of assault, then they shall be charged with, they shall be imprisoned to 5 years in jail. My ladies and my lord, we take the case of Guyo to heart. We understand what has happened. And as the country, under Article 244 of the Constitution, we have established the National Police Service. It has an obligation to investigate this case. My ladies and my lord, once a case has been produced before the right avenue, then the right judgment shall be issued. Pass on to the fact sheet, paragraph number 16. There was a charge of 10,000. There there was Dukia was released on a cash bail of 10,000, but she was only charged with assault. My ladies and my lord, we as the respondent take the right responsibility to ensure that the right charges have been instituted against Rukia, against Sony, against Rehema recruited agency, who managed to ensure that this particular form of child trafficking, which we are against, happened. My ladies and my lord, my ladies and my lord, if I may go further to demonstrate before this honorable court, in the case of Doris Kemunto versus Republic, 2020 case, the Kenya law reports. My ladies and my lord, in this particular case, a child of the age of 3 years was deprived of parental care and love. She was trafficked into another country against Section 3.1 and 3.5 of the Counter-Trafficking Act of 2010, which we have implemented as a country, my ladies and my lord. The right judgment was issued, therefore, she was sentenced to 30 years in prison. When they appealed this particular sentence, it was declined. My ladies and my lord, in a celebrated landmark ruling in 2021 before a magistrate court in Shanzu, where a Nepalese had confiscated passports belonging to 60 individuals who were supposed to be deported.
Come again with the citation of that case. The celebrated case that you've just mentioned.
Thank you, my lady, for your question. The case is Ahmed and Ocharo 2019 case. I found this data under the Equality Now 2022 while we were doing our research on the types of cases that had been presented before the court, my lady.
Of the High Court or a lower court?
It is a case from the magistrate's chambers, and we submit before this honorable court that this case may be of persuasive nature. With the permission of this court, I'll wish to proceed. Thank you, my lady. My ladies and my lord, we submit before this honorable court that the act of preventing the trafficking of children, the abuse of children, is an ongoing cycle, which as a government, we are not relenting until we ensure that the same has been taken care of and the same has been ended. My ladies and my lord, we have enabled individuals under our constitution, my ladies and my lord. By ratifying all these conventions under Article 2.5 and 2.6 of the constitution, it shows our good faith as a country to ensure that these children's rights have been protected. And in the event where we've overlooked these particular rights, my ladies and my lord, we go back to the drawing board and make sure the right action has been taken. Seeing my time has been much spent, I'll request for a few seconds to submit for our prayers before this honorable court, if the bench would allow.
You require how many minutes?
30 seconds, my lady. Okay. Thank you. On our prayers, my lord and my lady, we submit before this honorable court that in light of the arguments that we've advanced before this honorable court, that it finds that this matter is inadmissible. Why do we say so? Because the applicants have not exhausted all the available remedies that they have before appearing before this plane. We submit that this court finds that the government steps towards realization of trafficking in society has been hindered by communities and proportionate actions. We pray that this court find the government to have put in place adequate mechanisms that ensures...
Come again, what's your prayer number 2?
My lady, our prayer number 2 is that this court finds the government steps towards realization of trafficking-free society has been hindered by communities and proportionate actions. We pray that this honorable court finds that the government has put in place adequate mechanisms and to ensure international legislation which it is a party to. We also pray that this honorable court finds that the government has taken progressive steps in the realization of the best interests of the child. It is our prayer that this court finds the government not in breach of any international labor agreements as well as domestic legislation on employment. My ladies and my lord, as I finalize, we pray that this honorable court dismisses this matter for want of prosecution, as it was said in the case of DPP versus Wellington, that the prosecution must prove their case beyond reasonable doubt. It is a submission before this honorable court that the prosecution has failed to do so. I beg to rest my case.
Your Honor, the respondents have passionately argued. Your Honor.
Respond on matters of law. Restrict yourself to matters of law.
All right, Your Honor. Much obliged, Your The respondent have argued that we've not exhausted local remedies available for us. Your Honor, we submit to this honorable court that in the case of Okio Mtata, Okoiti, and another versus Anne Waiguru, the Cabinet Secretary, Devolution and Planning.
You cite that case during your submission?
No, Your Honor.
So you cannot bring a new case at this stage?
It is relevant to the submissions, what they have just argued.
No, you cannot introduce a new case in your reply. So just restrict yourself to what they submitted and answer only in matters of law.
Your Honor, the applicants, as applicants, we are shocked that the respondent argues that this court lacks jurisdiction to hear and determine the matters herein presented in this application. Your Honor, it is clear that the opposing counsel is not privy to Article 165, Clause 3 of the Constitution that confers this court unlimited jurisdiction to hear matters of constitutional violations. Your Honor, I think that's all for rebuttals for the applicants. Okay.
Thank you for your grace, my lady. In light of the question on exhaustion of remedies, I go back to citing the case of Nicholas versus the AG, a case in the Supreme Court of Kenya, meaning that it is binding upon this honorable court, where the court stated that it is actually opposite to the interest of justice to skip a remedy. Why? Because once you skip a remedy, my lady and my lord, you have eliminated a tier for appeal. You skipped the children's court, you've come directly to the high court. What happens if the high court gives a determination that is not in your favor? You want to appeal. You've already eliminated one of the tiers for appeal that was presented to you, my lord and my ladies. That is in the opposite of the interest of justice. It is detrimental to Guyo as a person seeking justice, my lord. Allow me to draw comparison to real-world issues, my lord. To the extent that even in the kitchen when you're cooking, you usually have a recipe to follow from first to the last step in order to end with that product. At the court, that we are seeking justice. Let's the process set in the Constitution in seeking justice, as was stated in the several cases. Thank you, my lords and my ladies.
Okay, Kazo, is just a question on the issue of jurisdiction. You have extensively tried to persuade the court that the court has no jurisdiction. At Article 23.
Of Article 23, my lord.
Article 23. Okay. If you have it, then read.
I don't have the Constitution with me, unfortunately. Sorry for that. Article 23 states authority to uphold of rights.
Yes.
One, the High Court has jurisdiction in accordance with Article 165 to hear and determine applications for redress of a denial, violation or infringement of or threat to a right or fundamental freedom in the Bill of Rights.
Okay. So do you believe that this case touches on violations of fundamental freedoms and human rights under the Bill of Rights?
Yes, my lord. But in response,
yes,
allow me to state that jurisdiction does flow indeed from the Constitution. And in all these matters, in some instances, the aim of the 2020 Constitution was to help in decongest the courts and help in making remedies available to the people. In so doing, a specialized court was created in the Children's Court as the court for first instance where questions of child rights are violated. The Children's under Section 23 is very specific, that questions on trafficking, questions on employment of children to do tedious work, questions of abuse of children will lie under the Children's Court as the court of first instance, my lord. we encourage a holistic interpretation of these statutes and the Constitution. That as we read Article 23, we go back and read the Children's Act. What does it say to us? It says to us that the Children's Court is the court of first instance, my lord. And as the court of first instance, this court indeed has jurisdiction, but as an appellate court, as a reference court, as well as a court for judicial review, my lord. I hope that sufficiently answers the question.
Okay. Now, they have alleged violation of international conventions. Okay? They have alleged the violation of international conventions.
Yes,
which is the right court for interpretation of international conventions?
Thank you for that question, my lord. We believe that indeed the Children's Court is a subordinate court. We take cognizance of that as established under Article 169(1)(d) of the Constitution. Most of the allegations that the applicants have brought forth can be gotten from our laws domestically, and they can get redress from the Children's Court without burdening the High Court, because the court is very busy. My lord, if we take this matter upon this court, what is the message that we're sending to the Children's Court? Is it that they don't have authority? Is it that they're just sitting there to get the salaries at the end of the day and make no impact in our jurisprudence, my lord? Another danger that exists is in creating a very harmful jurisprudence, my lord. A precedent where any party aggrieved will just skip all the remedies that are offered, skip all the subordinate court, skip all the tribunals, and move directly to the High Court. What happens if tomorrow Amka Justice Initiative get up and say, let's go to the Supreme Court straight, my lord? Okay. Will that really be in the interest of justice?
So the final question is that, does this court have the power to grant the orders that are being sought? That's the bottom line question. Or it does not have the powers to grant the orders?
Thank you, my lord, for that question. Allow me to echo the words of Justice Nyarangi as I stated. Jurisdiction is everything. Yes. And where a court has no power, it has to down its tools. Yes. My lords, my ladies, you have to down your tools.
Okay, thank you.
Okay, the court has considered the submission by the applicants and also by the respondents. We are going to retire to do our judgment, and you're going to come back so that we give you our verdict. The court clerk can proceed and adjourn the court.
All rise. So that is the end of our first session. The councils, you're dismissed. You can take your seats as we wait for the next team to take the stand. to 10 minutes. So all rise. Court is starting, all rise. We can settle down. With grace from the judges, you've been given 5 extra minutes, so 15 minutes for each team. We can start.
My name is Charlotte Mwathi, rising before this court on behalf of the applicants. I will take the next 7 minutes to discuss the issues on jurisdiction and admissibility. Thereafter, my co-counsel Lavender will take the next 7 minutes to discuss the issues to discuss the merit issues. We shall reserve the last minute for rebuttals. We stand here on behalf of Guyo, whose innocence and dreams have been shattered by the exploitation that she has undergone. In seeking a better life, not only just for herself, but for her family. Her experience reveals a stark reality, where promises are unfulfilled and justice is elusive. We demand accountability, not only from the institutions that were directly involved, but from those that failed in their obligation to protect. We implore this court to uphold the principles of access to justice, equity, and human rights that Kijani Kibichi purports to champion for. It is important to note that the laws of Kijani Kibichi do mirror that of Kenya. Furthermore, it is important to note that without jurisdiction, this court has no power to take one more step. And this is as held in the case of Lillian S. v. Catex Oil. I will structure my arguments in the following ways. Firstly, I will discuss on territorial and material jurisdiction. Thereafter, I shall submit that Amka does have personal jurisdiction and standing before this honorable court. Lastly, that the issues before this court are admissible. Firstly, I shall start with material jurisdiction. Seeing that Kijani Kibichi is a state party to the treaties and conventions as enshrined in paragraph 3, we see that Article 7 of the Minimum Age Convention was violated. This article states that employment of children between 13 to 15 years of age is only for light work. What is light work? Light work, as defined in the Employments Act, Section 56 2B, states that this is work that is neither harmful to the child's development nor to their school attendance. I shall turn this court to the facts of the case. Paragraph 11. Assuming that this court is with me, we shall read the 5th line starting with the word 1. We see that one particular bad incident happened where Guyo burned a shirt belonging to one of Rukia's children. This happened on the 26th of May, 2023. Rukia therefore responded by placing a hot iron on Guyo's shoulder. We do see that this is detrimental to her health and well-being. Furthermore, paragraph 13, assuming that the court is with me, states that she had to work from 4:30 a.m. in the morning till 10 p.m. where she had to make sure that Rukia's husband was fed when he arrived home late. This prejudices her school attendance. Furthermore, we have the Counter-Trafficking Act in Persons, Article 3.1, that defines trafficking as, this is the recruitment, transportation of a person for the purpose of exploitation. We do see, pursuant to paragraph 7 and 8 of the fact pattern, that Guyo was trafficked from Kilimobora and she was brought into Kijani Kibichi. And thus, that asserts my position, that this court has material jurisdiction. On to territorial jurisdiction. This refers to whether a court can look at the matter in the area where the action arose. And this is held in the case of Republic v. Magistrate. Now, the rule here that is being relied upon is concurrent jurisdiction. This is where jurisdiction is concurrently exercised by more than one court over the same subject matter. Here, we rely on the effects principle, which states that the case ought to be brought in the court in which the state mostly felt the effects. Pursuant to the facts that we have before this case, we do see that Guyo was trafficked into Kijani Kibichi. However, most of the effects of child labor were felt within the state. This position was further emphasized in the SS Lotus case, which is an international law case. Therefore, it is the applicant's submission that this court does indeed have territorial jurisdiction. On to admissibility. Pursuant to Article 23(1) of the Constitution, we see that the High Court has jurisdiction in accordance with Article 165 to hear cases that address the violation of a right. Furthermore, we see that Article 165(3)(a) holds that the High Court has jurisdiction in criminal and civil matters. The case before us is a criminal matter. How do we justify this? The violation of human trafficking is a criminal matter pursuant to Article 5 of the Protocol to Prevent, Suppress, and Punish Trafficking in Persons. This is further emphasized in the case of KKR v. Republic. Child labor, furthermore, is criminalized in the Penal Code as per Section 266, which states that this is the unlawful compulsory labor. And unlawful compulsory labor is labor against the will of the person. The matter in this court, therefore, is justiciable and thus contravenes several statutes as mentioned in material jurisdiction. Lastly, I shall conclude on personal jurisdiction and standing. Pursuant to Article 22(1) of the Constitution, we do see that everyone has a right to institute a matter before this court. Article 22 says that a person can go on behalf of a group or class of persons. In this case, Amka is acting on behalf of Guyo. It is therefore my submission that this court does indeed have the requisite jurisdiction and that the matter before this court is admissible. In conclusion, we illuminate a promising reality for Guyo where commitments are honored and justice is diligently pursued. Seeing that my time has run out, I shall cede the floor to my co-counsel Lavender, who will take the next 7 minutes to address the issues on the merit issues. Thank you.
May it please this honorable court, my name is Lavender Masai, and as my co-counsel stated, I appear on behalf of the applicant. I shall take the next 3 minutes to prove to this court that the state failed in its obligation to protect the rights of the child. Guyo is a 13-year-old girl who has been subjected to immense suffering. She woke up at the crack of dawn, went to bed in the wee hours of the morning. Additionally, she was confined to the 4 walls of Rukia's home. Moreover, as my court counsel has pointed out, she was subjected to various forms of abuse, which include being burnt by a hot iron box. In Nelson Mandela's words, we should reach out to the children and do our best, do whatever we can to ensure that we support the children as they rise above the suffering and harm that they have been inflicted. Your Honor, it is our submission that the state has a duty to ensure that the rights of the child are protected. In this case, the state has a duty to protect the rights of the child in regard to ensuring non-state actors fulfill and act in accordance with the laws of the conventions and the laws that are stipulated in the laws of the country. Your Honor, Rehema Recruitment Agency is a non-state actor who has been involved in a stage of trafficking. Which stage of trafficking, you might ask? The stage of trafficking that they have been involved in is the recruitment stage. Your Honor, if I may guide the court to paragraph number 8 of the fact sheet, where it states that on arrival to Kijani Kibichi, Guyo was taken to Rehema Recruitment Agency. It is evident that Rehema Recruitment Agency has participated in the offense of trafficking. Consequently, it is our submission that the state has failed to fulfill its obligation to protect the rights of the child. Additionally, Your Honor, seeing as my time is almost up, I will move into the issue on child labor. The state has a duty to investigate all crimes that occur. This was the position that was held by the General Comment number 5 of 2018 on the state's obligations in accordance to the ACRWC. Additionally, in CK, the Commissioner of Police, the states held that the investigation should not only be conducted, however, it should be conducted effectively and in accordance with professional standards. Your Honor, Article 4 of the ACRWC states that the best interest of the child should be considered in any and all actions pertaining to children matters. It is our submission that the state has failed to fulfill this obligation because they only investigated the matter of assault. And Your Honor, as my co-counsel has depicted, Guyo was subjected to so much harm. It is not only assault that is evident in this case, there is also child labor and human trafficking, as we have evidenced. Additionally, Your Honor, due to that, we also hold that the agency is still registered. Therefore, it can still do what it has done to Guyo to other children. Therefore, Your Honors, we beseech you to prevent another child from being subjected to what Guyo was subjected to, as this court can hold that the police did not fulfill their obligation to effectively investigate the matters before this court. Your Honor, in accordance with Article, Your Honors, in concluding my submissions, I will state that we as the state have shown that we as the applicants have shown the state had a responsibility to protect Guyo from child trafficking and child labor. However, they have failed to meet these obligations, as we have highlighted that they did not perform an effective investigation, and additionally, they did not ensure that Rehema Recruitment Agency acted in accordance with the convention that we have stated above. Therefore, Your Honor, we implore this court to find that the state has not discharged its mandate to protect the child in regards to child labor and trafficking. Additionally, counsel had earlier submitted, we implore this court to find that it has the requisite jurisdiction to hear this matter. Thank you, Your Honors. To address in answering your question, Your Honor, we ask that this court find that the court has the jurisdiction to hear this matter. Consequently, to hold the state accountable for what it has failed to do, because legally the state does have an obligation to protect the rights of the child. Thank you, Your Honor. For conducting an ineffective investigation, and as I have in my earlier submissions, Your Honor, I had stated that the state is bound to conduct effective investigations in order to ensure that they have protected the rights of the child. However, in this case, Your Honor, because the best interest of the child was not considered, the police have failed to fulfill this obligation. Hence, Your Honor, it is our prayer that you hold that the state has not fulfilled its obligation to protect the rights of the child.
The child are violated.
Yes, Your Honor.
So you want this court to enforce those rights? by doing what to your client?
Yes, Your Honor. Your Honor, we ask that compensation should be accrued to Guyo for all the damages that she has incurred, the immense suffering that she has been subjected to. Thank you, Your Honor. Today, as we stand at the precipice of justice, we humbly request this court to make determination.
Counsel, could you introduce yourself?
If you may, I will introduce myself. I'm just making an opening statement. Okay. May it please this honorable court, for purpose of record, my name is Khadija Hassan. Together with my co-counsel, Kamara Castro, we are appearing for the respondent, the state of Kijani Kibichi. Today, as we stand at the precipice of justice, we humbly request the court to make determination based on justice and fairness and to shy away from emotions. My Lord, we will look at 4 issues. The first one is the issue of jurisdiction, the issue of admissibility, the issues for determination of facts, and the prayers that we seek from this honorable court. I will take the issues for determination of facts. I will take 6 minutes to deal with the issue of jurisdiction and admissibility. My co-counsel will take 9 minutes to deal with the issues for determination of facts and the prayers we seek from this honorable court. If this suffices, I wish to start my submissions. On the issue of jurisdiction, Article 23 of the Constitution of Kijani Kibichi, read together with Article 165 of the Constitution of Kijani Kibichi, said that the High Court has unlimited jurisdiction to entertain matters in civil and criminal matters, but deeply has the jurisdiction to entertain constitutional matters involving the violation, infringement, or denial of human rights. It has been emphasized in the case of Samuel Kamau Macharia versus the Kenya Commercial Bank that if a court lacks jurisdiction, it should down its tools. As respondents, we do submit that this court has the jurisdiction to entertain this matter. On the issue of admissibility, although Article 22 of the Constitution of Kijani Kibichi states that every person has a right to institute court proceedings on behalf of another person.
In this court that you agree with the applicant that the court has jurisdiction?
Yes.
Okay.
Although Article 22 of the Constitution of Kijani Kibichi states that every person has a right to institute a court proceedings on behalf of another person who can't act on their own. But the Civil Procedure Rule, Order 32, Rule 2, states that for a next friend in court, they should be certified by the court. We can't see anywhere in the facts that the applicant was certified by this honorable court. In the case of International Center of Conflict Resolution versus AG, had emphasized that the High Court should shy away from handling matters that are still unsettled. Your Honor, we submit as respondents that the case is not admissible. on factors that the applicant was not certified by this honorable court, and the court is and the case is still ripe. We are still investigating on that case. The applicant, yes, approached us.
You have been brought before this court because you have failed to act. So just demonstrate to court what steps you've taken as the government to handle this case.
Okay. Thank you for your question. For the state of Kijani Kibichi, what the steps we've taken after Amka Africa had come to the police officers of Kijani Kibichi and reported the case of Guyo. We did arrest the one who aided in trafficking Guyo and the one who aided in child labor. But they had the right to be bailed. And still, my lord, pursuant to Section 35 of the National Police Service Act, states that the police has the Directorate of Criminal Investigation. The case is still handled in the state of Kijani Kibichi. We still need time to handle this case. This case is not ripe. Therefore, we submit that this case is not admissible. If there is no any further question, I yield the floor to my co-counsel. Paragraph 16, sorry. Paragraph 16 of the facts.
Paragraph
16.
of the statement of facts.
Yes.
Paragraph 16. 16.
Yes.
Okay. What does it read from your end? Paragraph 16.
At Tusaidiane police station, Guyo recorded a statement detailing her entire process from when she was picked from her parents' home in Kilimobora to eventual experience in Rukia's home. In her description, she detailed Sonia's recruitment from Kilimobora and her reception by Rehema Recruitment Agency when she got to Tusaidiane. After Guyo recorded her statement, she was referred to a nearby health center for medical checkups and for filing of the P3 form. The P3 form and the medical reports were availed to the police officers, which detailed that Guyo's injury had been inflicted during her employment. The P3 form classified the matter as an assault case, following which Rukia was charged only with assault.
Okay. So, on my end is paragraph 19.
Oh.
But they clear that he was only charged with assault.
Yes.
Okay. Thank you.
There is no any further question. I yield the floor to my co-counsel.
Okay, my name is Kamara Castro. I'll be dealing with the issues for determination, and also I'll be seeking prayers before this court. My Lord, injustice anywhere is a threat to justice everywhere. An issue has been presented by the applicant, by the petitioners, that the state of Kijani Kibichi failed to protect the rights of Guyo. But I would like to submit before this honorable court that, my Lord, indeed we are making the progress. The general comment number 12, paragraph 12, states that state in pursuing an obligation can do it in its minimum. So the process we are doing, we are pursuing the matter at every step. If you check the facts in paragraph 5, you'll realize that Guyo is trafficked to Kijani Kibichi on the 2nd day of April 2022. And the matter ends on 15th day of August 2023. What does it mean? It means the matter took a long duration of time. It is a duration of 1 year. There has to be process, my Lord. It has to be pursued to its fullest. there is a chain of events. And the chain of events has to be passed through investigation, through making progress, through making steps. I would like to submit to the court that indeed the state of Kijani Kibichi made progress. In the case of International Center of Conflict Resolution versus the AG, it is clear that this case is not ripe for determination. We are in the process of pursuing the matter and request the petitioners to give us time to pursue the matter. As a state of Kijani Kibichi, we respect and value human rights. As the state of Kijani Kibichi, we respect and have dignity. And that is why if you check our constitution, pursuant to Article 30, it means if you read Article 30, you will realize there is protection from slavery and torture. And if you read Article 53 of the Constitution of Kijani Kibichi, the right of a child. My Lord, the police officers in Kijani Kibichi are in the process of pursuing the matter. And we have even the internal mechanisms that we can explore. If you check Section 35 of the National Police Service Act, it has established the Directorate of Criminal Investigations. My Lord, we are in the process of making the matter and pursuing the matter. And we request this honorable court that the matter has been presented before you. And even if you check from the facts, even the available things that they ought to have done. The first, there is establishment of Kijani Kibichi Human Rights and Equality Commission. They have the sole mandate to investigate. It is a government body, my Lord. So it Amka Africa rushed to court to sue the government for failing to protect this right. Yet the government is in the process of protecting this right. I mean, acting on the matter. The issue has been raised on Rukia, if you check paragraph 16. Rukia being released on bail and bond. And we would like to thank the petitioners. You have presented and you have brought this child to record the statement. If you check paragraph 15, the statement was recorded with their help, and we thank them. So the thing that is here is, as you have recorded and brought the child to record the statement, we are pursuing the matter. Pursuing the matter is leave it to the police officers. Leaving it to the police officers means taking a step to the Directorate of Public Prosecutions pursuant to Article 156 of the Constitution of Kijani Kibichi. What does it mean? It states that the Directorate of Public Prosecution has a mandate to charge the offenders. My Lord, an invitation was made, and even if you read the fact sheet, there was a meeting. But now, Amka Africa wants to make a determination on the type of offenses that should be charged against the perpetrators. My Lord, we beseech you and we seek the following remedies before this honorable court. The first remedy is to dismiss this suit. The second remedy is to make a determination that the state of Kijani Kibichi be given time to pursue the matter to its fullest. The third is that to make a determination that indeed the state of Kijani Kibichi has not violated this right, and the state of Kijani Kibichi is in the process of dealing with this issue. Thank you, my Lord.
Counsel, I would like you to address the court on the following points.
Yes.
First of all, do you appreciate the nature of this case as a government?
Yes, we do. It is a case that involves child trafficking and forced labor, we do admit.
Secondly, you have demonstrated that the state actually charged with assault.
Yes.
And you say it is a process.
Yes.
Could you address this court on the issue of appreciating that this is a child trafficking, which is a human violation and assault? Could you demonstrate that the step that the state took is sufficient to provide protection or give justice to the victim?
My Lord, the fact that if you check the fact sheet on paragraph 16, you'll realize that indeed the matter was reported to a police station. We made our premises accessible. Making our premises accessible means we were ready and we are ready to pursue the matter involving human rights. And the state of Kijani Kibichi, we recognize that indeed there is violation of rights of Guyo. And we do admit before this honorable court that in the process, the steps we are taking currently is we are pursuing the internal remedies, internal mechanisms available to deal with the matter. One of the obligations conferred to us in the transnational organized crime of 2000, supplemented by the Palermo Protocol, is that there has to be exchange of information. My Lord, we are exchanging the information of the state origin of this child. We have to move to the border point. We have to we have to pursue the matter.
Counsel, you've taken 1 year to investigate. What more time does the state need?
My Lord.
To conclude on this matter and charge?
My Lord, the state has not taken 1 year to pursue the matter. As I submitted earlier on, that this matter occurred the day she was granted transit passes to Kijani Kibichi is on the first day of April 2022 to 15th August 2023, where she's now at. She's rescued and she leaves Rukia's house. What does that mean? What I was inferring means that indeed the issue took 1 year. It is a matter that has not occurred within a day. So we are in the process of pursuing the matter. It involves different chain of events, and as emphasized in the case of Mohammed Asir versus the Republic, 2017 Electronic Kenya Law Report, it states that issue involving child trafficking, there are different steps. There's a step from, there is aiding, there is step of recruitment, and there is step of movement. So we are in the process of pursuing the matter. The matter took 1 year, and we request this honorable court that it is not a matter that can be pursued within few days. It is a matter that took a duration of time, and we are requesting this court to give us more time to pursue the matter.
Are you aware that there are absolute rights that cannot be limited?
Yes, we are.
Can you address me on that? Address this bench on that.
The fundamental right that cannot be limited is pursuant to Article, let me just check. Just a minute, my Lord. Yes, indeed. It pursuant to Article 25 of the Constitution of Kijani Kibichi. And one of the rights that cannot be limited is, freedom from torture, freedom from slavery, inhuman treatment. Yeah.
Said.
Yes.
And has that been done to the victim in this case? Has that right been infringed?
We submit before this honorable court, my Lord, that as you had said earlier, we recognize right. And indeed we admit that these rights were violated. These rights were violated by the perpetrator. But what we aver is that we be given time and we are going to give justice by the Directorate of Public Prosecution charging the perpetrators with the offenses.
This is a case involving a minor.
Yes.
Is 1 year reasonable for the state to conclude investigations and bring the perpetrators to book? Matters touching on children?
The matters touching on children, they should be done in the favor of, in best interest of a child.
The disposal of such cases?
I stand to be guided by this honorable court, my Lord.
Very well. Let us get the reply.
Yes.
you recognize that this is a child, 15 years old.
Yes.
And this child is not in school.
Yes.
So what, and for the period that you have said, the period you have taken, you are still investigating, this child is not in school.
Yes.
Is that a specific right of the child that is being violated in your, with your knowledge, with the full knowledge as a state?
My Lord, currently the child is at one of the agencies of Amka Africa.
Oh, that's not a school. Is it a school?
It's not a school, my Lord.
Okay. Thank you.
Your Honors, the applicant have claimed to have investigated their matter, and in doing so, they have claimed that they have fulfilled their obligation to protect. However, the obligation to protect in regards to the investigation of a matter must be effective. As this court held that in the case of CK versus Commissioner of Police. Additionally, Your Honor, the applicants have stated that they are in the process and they are taking measures to ensure that they fulfill the protection of the rights. However, pursuant to Article 5 of the SARWC, the state is obliged to take the maximum extent in protecting the rights of the child. Therefore, merely offering a commitment does not meet this threshold. Therefore, Your Honor, we conclude that contrary to what the state has submitted, the state has not in fact fulfilled its obligation to protect the rights of the child.
Thank you, my Lord. As you had stated earlier, we don't want to bring a case before a court of law that is going to fall. We don't want to bring a case before a court of law that is going to be to fall, and the perpetrators are going to walk free as alleged. So as we had stated earlier, we request the Honorable Court to give us time to deal with the issue. Thank you.
Yeah, a quick question. What do you mean by you need more time? How much time do you need? Because you didn't say the child is in an NGO, Amka Africa. You are not doing anything about it. So how much time do you need for that child to have justice? And what do you mean by justice? Can you define justice and what you will provide the kid with?
Thank you. Thank you so much, my Lord. As I had said earlier, that recognition of human right, we have recognized human right. And the reason why we are requesting for time, and the reason why as Amka Africa wants us to pursue the matter as fast as possible, is because, as she had said, it has different chain of events. There is event of transit passes being given. There is event of her being taken to, Rehema Recruitment Agency. There is an event whereby she's being taken to Rukia's house. So we want to provide a case that is of cogent evidence. So we are in the process and we request more time of a period of 3 months to deal with the matter. Thank you.
counsel for the applicant and the respondent. We have heard your submission, and we are going to give our ruling on the same. So the court is adjourned.
Court is adjourned. We can all rise. We will allow the judges to leave as well as the counsels, and then we can settle down. We can have a seat.
Thank you. Yes. Yeah.
Anyway, I'm just going to gaslight. But anyway, in the second round, we had two teams. We had our very own JQuat. A round of applause, guys. And we had Strathmore University. A round of applause. So in this round, it was very contested. The difference was with, okay, Stasem. But anyway, the best team in that round was Strathmore University, AA06.
So I think the teams that are proceeding, they're preparing? Are they here? Or they are going to prepare?
So because in the previous rounds, MB University went off as respondents, in this case, they will switch. So AA06 will be going as respondents, AA05 will be going as applicants.
We shall tell you when you're ready to proceed, when the judges are here and the bench, all the judges are here and the bench is fully constituted. Anyone, any other comment on the moot or comments on modern?
So I did a little bit of a comic, so we are just going to go through it. We won't read by one. We are just going to go through it. I'll ask you a few questions. I know a lot of you people, I'm also, because I'm the program manager, I'm the main logistics person. So I had your questions about water, so water is being distributed, yeah? So, yeah. So the first thing we have there, we are having Lydia, who is a lady who owns a house help recruitment agency here in Nairobi and has gone for the December holidays, huko Kakamega. The reason we chose Kakamega is not because of discrimination or a stereotype. It's because there's a research that was done by the Freedom Fund called Hidden in Plain Sight. Hidden in Plain Sight. If you want to Google it, you can just Google it. It was a research on child domestic work, or rather domestic child labor in the country. And areas, Western and Nyanza provinces came as the very first counties whereby a lot of children are trafficked from to come and work in Nairobi. Yeah? So that was the reason that we chose that, just to bring that out. Now, the research, as I've said, says hidden in plain sight, meaning that domestic child work does not always come out like very clearly, whereby you are told, hey, wewe kuje uende ufanye kazi. For some, it's like that. But for most people, it's different. Like the cases that Amka, I don't know if Milka spoke about what we do. We don't just do moot courts. This is just part of what we do. We also do the provision of legal aid services to victims, various people, but for this particular project, for victims of domestic child labor. And most of the cases that we get are children who are trafficked, but they did not expressly come to Nairobi or elsewhere just to being told that they are coming to provide domestic child labor. Most of them came being told, I'm going to take you to school. Others came being told that, for instance, like the way we are seeing Lydia here, she told the aunt that she's bringing the child here to come and, she's bringing LOD here to come and be sponsored by an NGO to go to school. So that was what happened. So when LOD was coming here, they thought she is coming to go to school to be sponsored by an NGO. So I've already finished page 1. So, page 2, sorry. So now we go to page 3, yeah? So we see LOD has now come to Nairobi, has been placed in a recruitment agency. As you heard even when Beryl was talking, she was recruited through a recruitment agency. For most people, it's about the bureaus, the domestic bureaus that we see huko nyumbani zimeeka, if you want a house help. She was recruited by a recruitment agency, which brought her here to Nairobi, and where she was told to stay in if you notice, she's at Usaidizi and there are other children. It's not just her. So it's looking like a boarding school. But in real sense, it's just it's a child trafficking center. And then now we are seeing this lady who comes and says that she's looking for a house help because women older than, for most of the time when she's working with other women who are older than her, they keep challenging all the instructions. I put this in English because we are having some people who don't speak English, don't speak Swahili, not from Kenya, so najua hawajafika. Si tungine tunafanana si wote. But they are coming. So that's why we put it in English to ensure inclusivity so that all of us can understand what the comic is saying. So we see she's saying that she wants someone who is who will not challenge her instructions. The reason is that I put that there is because the research for Hidden in Plain Sight found that most people who employ child domestic workers, they deem them to be kinder, to be more easy to control. And so when you see your aunt home, huko anasema wacha mimi natafuta msichana mdogo wa kazi. Now, you have to look at this. Is that a child who can legally be employed? Is this child domestic work just happening just in front of you? And that's why we are saying it is hidden in plain sight. Plain sight, just in front of us and with the closest people to us. On the other hand, we are seeing, she's saying that she has held Western, girls from Western and Nyanza are good workers. This is a stereotype we all know when you're at home. Most people say Western domestic workers from those sides are very, they do their work better and everything. But now for the children, they are deemed the children that are coming from there are more likely to do better work and to be kinder. Now let's go back to page 1. Now we are seeing now LOD has gone as the kind domestic worker to go and start working, and we are seeing the abuse start. Because when you say someone is easy to control, it's not always a good thing. Because when you say someone is easy to control, it means the other person has more power. And when they have more power, a lot of time we get abuse this power. So we are seeing the employer, Floria, the employer there, we are seeing her abuse Elodie. We are seeing that Elodie saying that she's just hungry, that's why she had not cleaned the bathroom. We are seeing the time. I hope you are keen on that. Everything in this nini, it's like venye tulikuwa tunasoma set books. It's everything has a meaning, even when they cough. There is a meaning hidden there. So when you see at Floria's house at 7 p.m., she's being yelled at. That's not fair for a child, to be honest, to be working still at 7 p.m., to be told about cleaning the bathroom. At this point, they're saying they're hungry. And then we see the other thing is where we have the next Sunday at 9 a.m. For most of us, let me just ask, because I think I'm speaking a lot, maybe at this middle side, when you have a domestic worker, how many rest days are they entitled to legally as per the employment laws?
Okay, sorry for interrupting, is in the comic and the conversation that is happening. Where are the teams that are proceeding? Are they in? Both teams? Okay. So there were comments that were to be made. I think at this point, because the guests are about to get here and we start in the meeting, I think it's important for them to get some tips from the judges so that we can have a better improved discussion going forward, okay? The other thing is, I still, personally, as an independent observer, I still felt that you still didn't pay justice to substantive issues. And this Moot court, si mambo na legalism ya kotini, is mostly, it's also an educative Moot court. Ni ya raise awareness to community. That is the major reason and for this Moot court. So you need really to synthesize actual facts. And I even gave you tips in the morning of some cases, modern cases we are talking about. I'm not hearing you putting out facts on modern slavery from this. I'm not hearing you putting out facts properly on human trafficking. That case, the Wang versus Basfa, really defined what aspect you call modern slavery. It was a domestic work case. What actually, in factual case, amounts to domestic work, to modern slavery. And the judges were very clear on what amounts to domestic, to modern slavery. I need to hear proper arguments, otherwise hakuna mtu atawin. Yeah, because they are, okay. The judges will still give you, so mimi sina maoni hapo, hii ni threat bure. But what I'm saying is, let's pull out issues. These are things, modern issues. Don't tell us those 1970s cases about slavery when slavery was about owning people and holding them in the hands. Speak modern issues. It's the way you present yourself, it's the way you relate issues and the facts that give you. So we are going only on substantive issues. Mambo ya jurisdiction, tushakubaliana. This is Supreme Court. Okay, it's not really Supreme Court like Supreme Court so that you don't start arguing about jurisdiction of Supreme Court. But this is the next step. Jurisdiction is admitted, okay? For those who are non-lawyers, jurisdiction ni kusema, hii koti iko na power ya kusikiza hii kesi. Mambo ya kuiambia huna power imeisha. So mkuje mtuambie issues. So let's give the judge a few minutes. The judges who are in the morning, they can give some feedback to improve your argument. Then we are coming for Kivumbi. Trial advocacy. Ongea kwa
You have to know the applicable laws, the appropriate charges, ingredients of the offense, in jurisdiction, and the perpetrators and the victims. So as your lecturer says, Madam Wahu, I'm not getting any point that brings out the exploitation of this child. First of all, when you are bringing out this case, you must know that this is a child. And a child, no one can speak for a child other than the government, right? So once you have established that there was a recruitment in this other country, what do we call it? Where the girl came from? Am I talking? Please talk to me. Which country is this where the girl came from? Guyo came from? Kilimobora. She went to Kijani Kibichi. So, at Kilimobora, there is recruitment and transport. Sony used a bus to transport this girl. And when she crossed a border, and you must know this is a transnational organized crime. And there is jurisdiction, principle of universality. It's a universal principle. So you can prosecute it in either countries. So when you approve all that there is this recruitment agency. There's exploitation that has been enhanced by the recruitment agency. They are charging a high fees, okay? You are trying to tell the court how this child was exploited. She was being paid a salary, which they claim was going back to the mother, and 20% was going back to the recruitment agency. And again, she was remaining with nothing. She was working long hours. The condition of work was not conducive. There were threats, intimidation. She was also denied medical attention. So why are you bringing all this, the facts of exploitation? This is because you really need compensation from the government. The government should compensate this girl for all these damages. And that is why we say damages. You seek for damages for this girl. So High Court has jurisdiction to entertain these cases. And it is the High Court where all human rights cases are being enforced. So when you go to the High Court and you tell the High Court, look here, the government failed to protect this girl, and because of that, this and this happened to this girl. This girl was denied education. This girl was denied health care. This girl was denied food. So you want this girl compensated. This girl has gone trauma. This girl has got psychological issues. You want this girl to be taken to the hospital and, be compensated so that she can be treated and all that. And then you want the court to compel the government, because the government is sleeping on its job, to arrest and prosecute this case. Okay? I heard the respondent saying that we have done something. This case was discovered after a year. That is not enough. And whether it is police or prosecutions, it is the Attorney General that represents the government. So the police cannot come out to say, we did our part. And then the prosecution also comes to say, the police did not bring to us this case. You cannot shift blame. It is the government. You serve the same government. So the government ought to have known, even at the border. The government has police officers, control officers at the border, right? They didn't even, they were not keen when this Sony girl was passing with the Guyo. So they ought to have even stopped her and asked, this is a girl of 13 years, what is she going to do in this jurisdiction? She ought to be in school at this time. If she has been invited to go and visit, where are the documents? And you realize they traveled by bus, which means they might have used porous borders and gazetted routes. You see? And that shows the laxity of the government to keep watch at these borders. So I expected you to bring out that. Again, this girl called Sony took away the passport of the minor. Your passport is the government, the property of the government. And the Counter-Trafficking Act prohibits anyone who is interfering with your traveling documents. It is an offense. So I also expected the applicants to bring that out, that Sony took the property which is a property of the government, and therefore it infringed on her right to movement. She could not move because she did not have any passport. She was not allowed to communicate. You see, those are fundamental human rights. that ought to be respected. Another issue was debt bondage. You see, the recruitment agency said they take 20% until the money that they use to transport the girl is fully paid. So this girl, her security is pegged on the services that she's giving. And that amounts to forced labor and other abuses. Another thing I saw is about the assault. You find that the other offenses are under the Trafficking Act, but assault is under the Penal Code. So you should be keen to know under which provision of law do you bring the charges. The law does not allow us from charging the accused person under different statutes. So in this case, there's an assault that exists. So this assault will be together with these other offenses under Counter-Trafficking Act. And then during trial, now like this is not a criminal court, it is a civil court under the High Court. What we really want to, the prayer that you really want the court to address is about infringement of the rights of the victim. And this is under Article 27, where the government should treat people equally. Everyone should be is equal before the law. And then the impact of this offense in the community. It does not only affect the victim, it has affected a wider section of the community. Because suppose this girl escaped from this house, she could have gone to commit an offense somewhere to enable her come home. Okay? And again, this girl's education was stopped. The parents of this girl, who knows whether they used to receive money? And we also know, we have to tell the court, the reason why these girls find themselves in such a place, it's because of poverty. Okay? They are vulnerable, the vulnerability. They took advantage because of the vulnerability. And because this is a child, that the means, who started by telling you the act, the means, and the exploitation. So the means is the promise or the deceit or she was promised that she was going to go to school, but instead they turned out to be a domestic worker. So when you're a child, that is irrelevant. Whether they use any means of deceit or promise or any other thing, that is irrelevant because you are a child. So the moment they crossed the border, the contract was substituted. She was told that you're coming to do the beadwork twice, 2 hours in a day and 4 hours on a weekend. But instead now she was given house chores, whereby she could not even sleep, she could not have time for herself, she was not given any social security, no insurance. So all this is what we require you as the applicant to bring before the court. And as the state, it's too bad I fall on the side of the state. And most of the time, state wanatapatapa to explain how they have failed to protect the individuals. I expect the state to demonstrate the steps they have taken to protect that child. I expect the state to show us the partnership they even have with NGOs, because the approach that is given to such kind of cases is prevention, protection, prosecution, and then partnership. Prosecution comes at the tail end. So when you do not work in partnership with the NGOs, like the Amaki, it's called Amaki? It's called Amka. Amka Foundation? Africa. Yeah. Without Amka Africa, nobody would have known that Guyo was being violated. So it is good to partner, and these are the people who are very close to the community. So I'll let my brother judge highlight a few.
Okay. Thank you. I entirely agree with the sentiments expressed by the presiding judge. I will have wished to say I do not have any other useful thing to add, but just briefly, probably the presiding judge has covered a lot on the question of the law and the question of application of the law on the facts. covering the issue of the applicants, the side of the applicants, and also the side of the respondents. Probably mine is to add that this is also a learning session. This is a moot court. It's not a real court, so we may not be expecting orders from this bench that are going to be implemented after we disperse. So we may not be expecting someone to extract the orders and run against government officials. What we are expecting is that when you disperse, you are going to carry with you the lessons. And so we are members of a society, and these things are happening within our societies. And so we expect that when you go back, you'll not be working as law students. You'll be working as members of the societies who have acquired knowledge and information that you wish to share with the rest of the societies. So you may sit here as law students. I don't know whether the majority are law students or from the other groups, but where the lessons of a member of the society. And so when you're talking about domestic work and a child domestic work, these are people or cases we are very much familiar with, and we see these things every day. But probably we have never associated them with law. So we think it's a normal way of life that a small girl leaves the village and goes to the city to work. It really looks normal. We meet these people every day, and nobody stops to question, by the way, what is the problem here? We never see the problem. We never identify the issue. So the purpose of this moot court is to help you. Next time you walk around the estate and you see these girls, you may pause now and ask, what is it that is happening here that is not right? That ability to pause and ask those questions probably is the only information that we want you to have. Secondly, now that you have paused and asked those relevant questions, we're also helping you to know that there is an avenue where you can have those issues addressed. So the knowledge of the problems and the knowledge of how those problems are to be addressed. And so in terms of identifying problems, the problem statement is just a reflection. It's not like that's the only thing that happened. So when you are talking about violations of human rights, you need to put them in real context, exactly what is happening that amounts to violation of human rights. So when you're talking about, for example, exploitation, that's just like a big word, but on the ground, what is it that is actually happening that amounts to exploitation? So like in this case, someone is working, but is not earning a salary. Or they are working, but they're earning half wages. We know very many cases of children who are working, but they're not being paid because they are relatives. They are staying in our house, they are eating food, so there's no need to pay. Those are points of exploitation. So the purpose of this session is to help you identify those points of abuse, those points of exploitation, and those points of violations. So when we talk, we use words like violation of human rights. It hides so many things. But behind that, behind those words, what exactly are we talking about that is happening on the ground? That's what you need to pick. This kid is not going to school, and you look around and you see so many kids who are not going to school. They are staying with their relatives somewhere working. Those are the points of exploitation or abuse that pass before our eyes without detection. Transfers from one place to another again. So when it comes to children, there are so many things that we can pick. So this session is helping us to identify those areas, and that's what we need to carry home. You may not be really expected to go and file cases and fight, but at least with this knowledge, you should be able to report or to refer the matter to the relevant authorities. And we're also helping you to identify these authorities. They could be NGOs, they could be government agencies, and all that. So when it comes to the government, some of you probably will be also going to work as government officers. So again, it's your duty to identify areas in which the government is required to help promote, preserve, protect the rights of the children. So what is it that the government is doing? So you need to demonstrate how the government is fulfilling its obligations. You might as well show us that the government is doing nothing. I think there's a group which was showing us that the government is actually doing nothing. So that could be the situation on the ground, that the government is doing nothing. And then it could be an indication that something needs to be done. So thank you very much. We will proceed that way. It's a learning session.
Thank you, Judge. It's a learning session indeed. So please, the next group, now it's going to be a bit advanced. Work on your presentation skills. As you present, pause, look at the judge. If the judge is not writing, pause and see whether this, the argument you are bringing forth is making sense. Don't rush. So work on your advocacy skills. Another thing is, there's a lady, a police officer, who raised an issue of using the child's identity. The law provides that you should not reveal the identity of a
I have a question as it relates to the rebuttals. I realized you flagged both teams when it comes to rebuttals. As far as I look at the question, the issues are quite not framed, but each of either the applicants or the respondents are framing the issues that are supposed to be debated, supposed to be mooted on. So if the applicant has 3 issues, substantive issues, then the other side has 4 issues. When I have submitted on 3 issues and the respondent has submitted on 4 issues, there is an issue that I have not submitted in my arguments. That means in my rebuttal, I have to again rebut on that specific issue, and that will invoke me coming again with an argument that I will not have raised. But now the bench flags that argument. So I was thinking, don't you think as the bench, just a humble suggestion, in the next round, then you would allow in the rebuttals, if there is an issue that has been raised by the respondents that was not raised by the applicants, ought to be rebutted by the applicants in their rebuttals. And then the respondents can respond to that issue when it's rebutted, because at the end of the day, it feels like the respondents have a higher chance in this moot because they can raise new issues and the applicants don't have really the opportunity to rebut those issues. Yeah.
Thank you. That's a good question. You know, when parties come to court with their cases, you know what matters you want to determine, establish. So you can, and they have 5, okay? And when you raise your 10 issues, because they are the applicant, okay, they're the people who have brought the state to court. So they will have a right to respond if the state raises anything that they did not touch on. That is why we say a right of reply. But in real sense of our trial in court, when they submit their case, and then they also submit their case. They have a right to reply, and they will only touch on matters of law only, which restricts us to matters of law. But because of the purposes of studying, learning, we allow them to rebut on the same. Okay? Initially, I started thinking like I'm in the real courtroom, but then I thought like, this is a learning session. That is why I allowed them to respond. Okay? But nothing stops you from coming with whatever number of issues you want to, the court to determine on.
Okay. Then just to add, as I said, this is a moot court, so there is a flexibility on issues of rules. But I would say probably in the real court scenario or real case scenario, you may not find that a party has been ambushed with issues on the floor. We exchange. In fact, we are encouraged to file agreed issues, which means we agree on the issues in advance and prepare our submissions around those issues. So there will be no new issues popping up on the floor. So probably that possibilities. That's why in real trial processes, there may be no room for the respondents to rebut. So because that right is only available to the applicant. It's assumed that during their presentation, they have tackled all the issues they have. So it's only the applicant now who has a right to see if there's anything new that the respondent has raised that was not raised during. But for now, we are saying, I was also equally surprised that the respondent was being given a chance to rebut, but they are now doing it.
Okay, thank you. I just felt the learned judge was a little bit hard on the applicants who submitted. So yeah, thank you. We will file our submissions within 14 days.
Yeah. Apologies for interrupting, but the following persons, if you can just move to the registration desk very quickly. The representatives from Set Free to Thrive, Lillian, Evelyn from Heart Kenya, Margaret Njoroge from FTS, Evelyn Grace from the Department of Children's Services, Alicia from Maisha Girls. We have Lucy and Mohammed from IOM, the representative from Mauno Africa, the representative from AICS, Robert Mwanzia from CHTE,
For the purpose of learning, I'm seeking the court clarification on whether we are in a civil court or a criminal court, because I'm noticing the conduct and the words that are being used is like we're talking like we're in a civil court, and then we're shifting and we're using the terminologies of a criminal court. This is based maybe on my limited understanding of criminal procedure. If it is a criminal matter, we could have been having Republic versus. And now, the conduct of the court, now I'm seeking just clarification on that. Is this matter civil or criminal or both?
Thank you. That's a good question. This is a criminal case. And because nothing has been done to bring this case to court, the fundamental human rights have been violated. So the High Court is the only court that can entertain such application for enforcing a violation of human rights. That is why I say any constitutional matter touching on the constitutional rights, you go to the High Court. So the High Court entertains, there are some applications in the nature of criminal and also civil. the first court, the High Court, is the first court to entertain such matters. But the case is criminal. And then you cannot run away from the facts of the case. Because by bringing out to this court the facts of the case is how the court will understand how this child was violated. Without bringing out the exploitation, this child was banned using an iron box. She was denied food. She was not being paid. You see, torture, being subjected to slavery, okay? And also not going to school. Right to education is a right to a child. Right to health is a right also provided under the Constitution. So you are running to the High Court to protect the rights of this girl. Yeah, so it's civil in nature, but the case is criminal. So by going to High Court, it will not bar these people again from ensuring that this case goes to court, because those are some of the orders they're going to seek, that the court should compel the government to investigate, to go to the root of this case and bring these perpetrators to book because they are known. Do you understand? Yeah.
Thank you. I hope there's clarity on that. Yes?
Yes. Yeah, I think also maybe your concern could be the issue of procedure. Maybe you are concerned about which then procedure we are applying. You could be referring to criminal procedure. So where we talk about the prosecutor, R versus the prosecutor, the accused person in the dock, and then witnesses being called. I don't know, maybe that's what you had in mind. So we are not in terms of procedure, we're not in a criminal court where we have the prosecutor and the republic and so we are in what I would call a constitutional court. Okay? So, and it's not a civil court like under civil procedure court. I know I had someone mention order these of civil procedure. We are not applying the civil procedure rules here. So we are in a constitutional court, although really it's a high court in Kenya. We don't have like a constitutional court on its own. It's a high court applying the constitution as sitting as such. So we have a constitutional and judicial review division of the high court. So we are in a constitutional division of the high court. So here, in terms of procedure, probably, it has its own procedure. So we are not applying criminal procedure and we are not applying civil procedure. It has its own procedure and it has its own rules of how to commence constitutional petitions of this nature. You are alleging violation of under the Bill of Rights. So you look at the Constitution and then you look at the rules of how to frame things. So, but in terms of nature, the colonial is not a criminal.
Thank you, Sid. To add, the reason why we have courts and operating in procedure, what is it? The procedural technicality of the Constitution. And so that's why you find then that this particular court that they're making reference to has flexibility in rules. Because you'll find there are very many issues in our country today that you can't strictly classify as criminal or civil. And if you try to classify strictly as one of the two, then injustice will be the end result. Do you have clarity on that? And so then that's why you find that flexibility. So that is the nature of this particular court. Any other question? Any other question or comment? We are just waiting for our guests and then we shall have the final round.
There's a point that the applicant raised that it is Amka Africa that went to court. And then the state was arguing that they do not have the locus standi. They do have. I like how the applicant responded, quoting the article of the Constitution, whereby even you right now, you see your neighbor beating the husband or wife. You have a right to come and report. And like previously, the complainant must just be the person who is being violated. So in this case, it is Amka Africa that came to court, and they are the applicant, and the Guyo is also one of them. They are representing. They are coming to court through. Guyo is coming to court through Amka because he's a minor. And then he's suing the state. And the state, you have to bring in the police, the Inspector General of the Police, the Director of Public Prosecutions. Yeah? Those are the respondents. So they are being represented by the AG. So any person who has witnessed violation of any nature can go and make a report or can make application before court. Yeah.
How is it going? How is it going? Somebody tell me quickly, how is it going? This team was doing very bad in the morning because they were looking very dull and hungry, but wait. How is it going, Grace? It's good. Okay, how is it going, this team? Awesome. How is it going? I think maybe you want to hear how is it going.
Good afternoon. My name is Josephine, and I am deaf, and I am speaking through my interpreter. I feel that it's a very good opportunity for me to learn, and I have really learned a lot so far, and I work with the community, the deaf community. What I have learned here,
I think our time is much gone, but we are okay. So, Dr. Keremi, are you in the house? Okay. So, Dr. Keremi, you can just come and start off the meeting again. Okay. So you can just start. And then welcome our visitors and everybody. I can see there are some new faces this afternoon.
Good afternoon. Good afternoon once more. Let me take this opportunity once more to invite you to the second session of these wonderful deliberations going on regarding children's rights and matters related to human trafficking. Let me welcome you to Jomo Kenyatta University of Agriculture and Technology, current campus, which is one of the campuses amongst others. Our main campus is in Juja, Kiambu County. We feel honored by the many institutions that have turned up for this great event. We thank our collaborators, the Freedom Fund, Amka Africa Initiative, representatives from our judicial system, the many universities represented here, and the human rights organizations that are present here. In the morning session, we had presentations by two teams, and I want to believe that those who were here since morning, the sessions have been educative, and as we continue, I want to believe that the level of awareness that we've been having regarding what can be termed to as a violation of the rights of a child. What is human trafficking? What rights do we have when you see a child's rights being trampled upon? So we are very happy by all those who thought about this initiative, because like it has been coming out from all the speakers and even the applicants, that we need to protect the rights of our children, because that is where our future is. So please feel welcome. We are honored to have you here, and let's keep our children protected. Thank you very much. Back to you, Mwalimu Wahu.
Yes, thank you very much, Dr. Kirimi, for blessing this meeting with the institution's blessing. Now, we have new members of court, people who have come to court late, or we are starting a fresh court. We have a new court. This is the Supreme Court. This is a final appeal. So it's a new day in court. Forget about the morning. The morning was the initial court, which you attended last year. The courts are slow. Your appeal will be heard after how long? Your appeal will be heard after how long? Yes, 2 years. So it's 2 years later. Now we are at Supreme Court. Our guest, the CEO, Freedom Fund, and all the other guests, board members, board chair, all protocols observed. And we really appreciate your presence in this. And we welcome you. Please have fun and participate. Even if you're not going to be the judge sitting here, all of us are judges of this moot court. We're listening to what is happening and enriching the discussions. So,
Hi, I wanted to ask, before you start the second session of the court, there's some few issues that we want to ask as part of disability in regards to some areas, because we are gray in those areas. There's this issue of slavery in issues to do with mental issues and spiritual issues. When a child who has a disability is being locked at home or been chained, I don't know which area, is it trafficking or is it slavery, or which areas can we ask as potential disability, because we encounter those issues at our areas, and how can we handle those issues before you start? I think for me that was the question I wanted to ask before you start the court. Or there's some laws which we can use at our place.
okay, thank you very much for your good question. It's not possible to answer you right away at this point before we start the court, but you are a member of Wote Kwa Wote, our partner. So we always conduct legal clinics with your group. So what we are going to do, we are going to structure a legal clinic training on these issues specifically. Then we can have an in-depth discussion and understanding. But in a without then much ado, I'm going to invite two more judges into the seat to come and make the panel a 5-bench bench because the court does not. So I'm going to invite the CEO of Freedom Fund. Come and sit here. Judges. You can sit there. We have another seat. Yes. It's Madam More, please. So Mr. Nick is the CEO of Freedom Fund. He'll speak to us later. He said he was alone. We just resume. Madam Moll is a board chair of Freedom Fund. So these issues, she must us doing the real thing. She's people playing or actually doing. Are you meeting the objective? Is the course being is on course? Is the course on? Teams, our lawyers, where are you? The court is about to start. Who is the court clerk?
All right, good afternoon. In the essence of time, can I please have the applicant, Embu University, AA05, to sit on this side, and Strathmore, AA06, the respondent, sit on the right side. Kindly bear with us for about a minute. Right. So we were dealing with submission of substantive. You out to jury, and each team will. That's okay. All right. Guys, court is now in session. Kindly mute your phones and adhere to the court rules. Sit now.
please this honorable, my lords and ladies in this honorable court, good, my lead counsel for the applicants in this matter, co-counsel Joseph Amaganga. I will proceed to take 7 minutes of this court allocated time, admit on substantive issues raised in this suit, while my co-counsel will also use 7 minutes to raise 1 minute. If that is in order and there are no further questions.
Honorable judges, if you my name
G to suffer the sling or through this honorable court as empowered Africa Justice Initiative up arms through this court's determination face this sea of trouble in the form of child trafficking, in the form of child abuse of and ladies. That argument as they are. Allow me to waited for us in this fact. We have is in life. She is inspired, wants to pursue her education, but she's on financial constraint. She comes from the state of Kilimabora, it's a neighboring country, and in this struggle to foresee the continuance of education, G happens to meet Son. That there is work back in bid work, that is, my lords and ladies. This work was not this work was and more hours on the weekends to allow to go to school and study. My lords and ladies, G is taken to Kijani Kibichi. At Kijani Kibichi, she is going to G is shocked. She formed the domestic worker. G is 13 years old. G is subjected to several kinds of verbal abuse, various that is can see that my lord can in a very dark tunnel, and at the end a light at that tunnel be another train coming on her. The police, the matter, up to no distance, the same. Today, in regard to government's response, as important by no law, as well as domestic of Kijani Kibichi, my lords and ladies. Let me address this court on the limb of servitude vis-a-vis modern slavery. My lords and ladies, it is evident in the fact sheet G Naturally, G is enslaved. G is enslaved to Rukia. G is enslaved to Rehem. Able to leave Kijani even if she wishes. Beyond that, see that G inside the house whenever Rukia leaves. Under no circumstances can we say that this employment was any further voluntary, my lords and ladies. The ILO 1930 outlines servitude, slavery, to compose where employment is exacted as a penalty, whereas this employment is involuntary. Allow me to cite a case in the European Court of Human Rights, a case of S versus France. This case, my lords and ladies, is a 2005 case. And in this case, S was trafficked all the way from Togo, brought to France. When she got to France, S was forced to work to raise her airfare back to Togo. S at that time was 15 years old. The person who had imposed this work on S further lent her out to a couple that was in France. This couple subjected S to work, where she was forced to work 15-hour shifts with no rest days, with no rest times. I know, my ladies and lords, that is very familiar, because those are the same instances of G. In this case of S versus France, the European Court determined that indeed the state of France was in breach of their duty imposed upon them by conventions as well as domestic laws. The facts of that case closely mirror the facts of our case here. And it is imperative that the determination from this court also mirrors that fact. Coming to domestic law, my ladies and lords, Article 25 of the Constitution creates absolute rights. These are rights that cannot be limited under any circumstances. Under it, we find freedom from servitude and freedom from slavery. It's written as or, meaning that they are one and the same, my lords and ladies. These rights cannot be limited. But what we have here, G having that right, freedom from servitude, being limited actively while the government watches. Now, perhaps you can say that it was employment. My lords and ladies, allow me to do some quick math for you. They say that lawyers are not good in math, but I'd like to dispute that today. G is supposed to work and be paid 6,000 Kenya shillings, Kijani Kibichi shillings, sorry. From this 6,000, half of it is supposed to be sent to her parents, leaving 3,000 for G. G, in this instance, is then forced to pay back a loan imposed over, a loan of 20,000 shillings at an interest rate of 20%. My lords and ladies, 20,000 shillings, interest rate of 20%. That's an interest rate of 1,000. It means that Guyo has to go back in her pocket 1,000, give to Rehema Recruitment Agency at the end of the month. My lords, is she really working, or is she being forced to work and pay the people who are employing her, my lords and ladies? That is absurd exploitation, and it is really sad to see. ICCPR, which is the International Convention on Civil and Political Rights, outlines clearly under Article 4 absolute rights that cannot be limited. Among them, freedom from servitude or freedom from slavery, my lords and ladies. Member states are tasked with preventing, and where perhaps it became difficult to prevent, lords and ladies, were launched from G, my lords and ladies. What was the difficulty in using the complaints as well to bring to institute proceedings against Sony, Rukia, Rehema Recruitment Agency? The questions that we raise today is in regard to the government's responsibility and under international law as well as the domestic law. They have a duty to prevent, they have a duty to prosecute. They have critically
leftovers. Bringing before this honorable court the story of the prodigal son as it is in the Holy Bible. Unfortunately, Guyo could not go back to the parents as the prodigal son could go back to the parents because her traveling documents had been by Rukia. Therefore, she was there to serve for slavery. This is against Article 25 Constitution of Kijani Kibichi, which provides for rights that might not be limited. Going further, my ladies and my lords, Guyo has never seen light during the time she has been at Rukia's place. It is provided for under paragraph 12. Rukia has always been locking Guyo in the house. I beg my ladies and my lord, that Rukia has always been locking G in the house. For all these years, it means G has stepped her foot outside the house in its baddest form. Imagine, my ladies and my lord, locked in this room for 16 months. Because as we calculate, from the 22nd of April to 23rd of May, when this issue came to light, to torture, being subjected to physical abuse, eating leftovers, and waking up at 4:30 and staying up to 10 for her to ensure she prepares food for the husband. The question that we beg an answer before this honorable court is Guyo really married to Rukia's husband? We submit before this honorable court that work with no pay is criminalized under the Employment Act. Thank you. Under the Employment Act of Kijani Kibichi. Every employee is entitled to leave. Over the 17 months that Guyo has worked under Rukia's guidance, she has never been subjected to leave. She went ahead to claim, like other workers, to be given a day off. This has never happened. Instead, Rukia could abuse her. I beg to pardon. The question that we raised before this honorable court, does it mean that also these other domestic workers are children? Is it only G? We submit before this honorable court that the police have a duty, which they have been mandated under Article 244 of the domestic laws of Kijani Kibichi to investigate such matters and prosecute them before the honorable court. We ask the question before this honorable court if they were capable of bringing the charges of assault based on the evidence that was recorded by Guyo. Were they not capable of bringing the charges on trafficking? Were they not capable on bringing the charges on child abuse? Were they not capable on bringing the cases on physical abuse? My ladies and my lord, we submit before this honorable court that G has suffered as a child, and that this honorable court finds that this court has failed in its the government has failed in its act in ensuring that it protects G against trafficking. My ladies and my lord, we submit before this honorable court, and in conclusion, that children are human beings to whom respect is due, and to whom they are superior to us by reason of their innocence and of their greater possibilities of their future. That was by Maria Montessori. And therefore, by these particular actions that have been done against G, they violated her acts to dignity under Article 28 of the Constitution. They violated her rights to discrimination as provided for under the Convention against elimination of all forms of discrimination against women, as well as domestic law. We submit before this honorable court that it finds the government to be in violation of international law and its own domestic laws with regards to the protection of G and all other children, and with regards to trafficking and child labor. Thank you. I beg to rest the case.
Counsel, before you sit down, you have told this bench about the exploitation that G went through. So I did not hear from your submission how the government has failed and what you want this court to do for you. So could you address us on that?
Thank you, my lady. You raised such an important question. With regards to the Constitution of Kijani Kibichi, the Director of Public Prosecution has been mandated to ensure that any complaints that have been raised, as they have enabled us under Article 22 of the Constitution, under Article 22 of the Constitution, that you can institute proceedings before the court where we feel like a right or fundamental freedom has been threatened. When this case was reported to, the police station, pursuant to paragraph number 18, Amka Justice has been following up on this issue, but there is no investigation that has been done. And therefore, despite G being taken back to rehabilitation center, the government has failed in its action to issue compensation, to issue proceedings that will lead to G being compensated for the harm that she has suffered. This government has failed to institute proceedings that will ensure that it bars further trafficking of children by getting Rehema Recruitment Agency to account, Sony to account, and Rukia for perpetrating child abuse.
Council, if I may guide you, we are now beyond the proceedings. We are now looking at the violation of human rights. And when the government violates the rights of a person who is under its duty to protect, you have to come to court. Now leave alone the proceedings. You have to tell the court that government has failed to protect this individual because it is provided under the UN Convention of Children's Right and Welfare. And that is right to education. And therefore, what we want from this is compensation. We want the government to be done for this. That is what I expect you to tell this panel. What do you want this court to do?
Thank you, my lady. Yeah. I stand guided. However, on that particular provision, we submit that the government has the duty under international law to protect the children. And the various provisions are very strict in they say that the government shall. It's not an option. And therefore, we seek that this honorable court issues orders to set up, that the government set up a comprehensive policy on elimination on all forms of child domestic work in Kijani Kibiti. We also pray that this honorable court orders that the government take action to ensure that G and many others who have been rescued from trafficking have been rehabilitated, and that this government ensures that education, as it has been provided for under the Basic Education Act of 2013 and the Children Act, to be free, so that these children won't have to be trafficked abroad for them to raise fees for them to attend school. Because, pursuant to the fact sheet, the main aim why G traveled abroad, it was because she could not foot for her, the parents could not foot for her secondary school bill, and therefore she had to go and work so that she can raise fees, for her to attend school. And therefore, we pray that this honorable court issues orders in that particular manner.
Judge President, honorable judges, if you may please this honorable court, good afternoon. My name is Charlotte Mwathi, rising before this court on behalf of the respondents. I will take the next 4 minutes to frame the issues we have before this court. Thereafter, my co-counsel Lavender will take the next 10 minutes to keenly dive into the substantive issues before this court. We shall reserve the last 1 minute for SAR rebuttals. As representatives of the government of Kijani Kibichi, we approach this court solemnly acknowledging to uphold the principles of equity, access to resources, and human rights as in our constitution. Recognize the gravity of the allegations that have been brought forth by Amka on child trafficking and child labor. We recognize the need for a comprehensive cooperation between both states in order to fight these two crimes and succeed in our march towards a transformative constitution. In order to safeguard the child before this court, we shall call her G. Turning to the facts, paragraph 3, assuming that this court is with me, we do see that Kijani Kibichi has ratified several treaties and conventions. Furthermore, we do see in the last line that also Kilimo Bora has ratified the protocol to prevent, suppress, and punish trafficking in persons, especially in women and children. Now, what am I submitting? I am calling for national cooperation between both states. Your Honor, we need both states to work together to fight these two crimes. We do empathize with G. We do acknowledge the two crimes that have been brought forth by applicants. Your Honor, we are honored and privileged to have Amka Africa Justice in our state. Turning to the fact, as of paragraph 50, assuming that the court is with me, we see Wit volunteer to Saidiane. He notices G after being kicked out. We do see that for Witu to acknowledge the gravity of the brought before this court, this is due to attending a sensitization program that was held by Amka Africa Justice Initiative, again, an NPO within our state. Your Honor, we do know that the functions of Amka Justice are to provide legal aid services. We acknowledge that they promote access to justice to the minority, vulnerable and children such as G. It is therefore our submission that we have taken a step to protect the child before this court named G. I will therefore cede my floor to my co-counsel Lavender, who will take the next 10 minutes to delve into the issues before this court.
Counsel, before I give it to your co-counsel, are you admitting that the government has failed?
No, Your Honor, I am not admitting. However, we sympathize with G. We do not take it lightly that these events, unfortunate events, have happened to her. However, as the government, we are taking steps to protect the child within our state. As I've mentioned, we are honored and privileged to have NPOs such as Amka, who took initiative, through WITU, took initiative to help this child, and that is why we are here today.
Do you appreciate that Amka Kenya, it's an NGO, and it is not its role to take the government's functions and duty to protect its citizen? Do you acknowledge that?
I do acknowledge.
Yes.
However, there are several steps we have taken to protect, not only in having Amka within our state.
And are you aware that Amka Kenya is the petitioner?
Yes, I do acknowledge. Yeah. However, there are more steps we've taken. This is just one but a step.
And you mentioned that Kijani Kibichi has ratified the same laws.
Yes, Your Honor.
So don't you think it would be important to have a bilateral agreement between two states on how to protect victims?
Yes, Your Honor, and that is why we are calling for national cooperation. Given that human trafficking, one of the allegations brought forth before this court, is a transnational crime in nature, we therefore hold that both states should have responsibility to tackle this crime together. I will therefore cede the floor to my co-counsel, who will further tell us how our state has taken steps to fulfill the obligation to protect. Thank you.
For purposes of learning, you don't need to call for cooperation now that an offense has been committed and a violation has taken place. So as your colleague submit before this court, I want your colleague to demonstrate how this government is protecting its citizens from violation.
May it please this honorable court, as earlier stated, my name is Lavender Masai. I appear on behalf of the respondents in this matter. And in Kofi Annan's words, there is no greater duty other than the duty to respect the children's rights and to protect the welfare of the child. This is why we are greatly saddened and appalled by all the injustices that Guyo has been subjected to. However, it is our position that we have met our legal obligation to protect the rights of the child. In my submissions, I will mirror the applicant's arguments. The applicants submitted that the state has failed to fulfill its obligation to protect in that it did not conduct an investigation. However, pursuant to paragraph 16 of the record, it is clear that the state took Guyo's witness statement, directed her to a hospital where she could file a P3 form. Additionally, the state has charged Rukia with assault. Therefore, Your Honor, the investigation, the fact that the state has investigated this crime and even charged somebody goes to show that the state has measures in place to protect the child. In further of my submission, Your Honor, we also state that in the fact sheet, paragraph 18, it is clear that after Amka Africa Justice Initiative came to the state police have offered commitments to investigate the matter further. And this is because of what my co-counsel had mentioned earlier. Some of the crimes, some of the offenses that are in question here are transnational crimes. And we hold that we would not have fulfilled our duty to protect the rights of the child if we brought this issue to be prosecuted, and it was not fully prosecuted because some of the parties that subjected Guyo to this trafficking are not present with us here today. As the applicants rightly pointed, the main reason as to why G came to Kijani Kibichi is because she could not afford her school fees. This is because in Kilimobora, the living standards are low. And Your Honor, this is why we are calling for national cooperation, because these are matters that we have to sit down with the other state and discuss in order to prevent such an occurrence from happening again.
So,
yes, Your Honor.
Apart from the investigations that is incomplete,
yes,
as demonstrated by the petitioners,
yes,
are there mechanisms that the government has put in place to prevent such crimes from occurring?
Yes, Your Honor. There are some legislative measures that we as a state have enacted. Article 15 of the ACRWC provides some legislative prongs for the state to meet in order to show that it is protecting the rights of the child. These include establishing a minimum wage, additionally establishing working conditions. It is our submission that through the Children Employment Regulations of 2020, these two prongs have been met, as the regulations provide that a child shall not be subjected to work for more than 3 hours without a 1 hour break, without a 1 hour period of rest.
Counsel, I don't want to lose you on your thought process.
Yes, Your Honor.
But the legislation you are quoting on paper,
yes,
I want something tangible that the government is doing to prevent and protect victims or its citizens.
On that, Your
Honor.
Honor.
Or anything that the government is doing to prevent such crimes from reoccurring.
On that, Your Honor, we do submit that pursuant to Article 59 of the Constitution of Kenya, there exists the Kenya National Human Rights Commission, whose mandate is to investigate and seek redress for anybody whose human rights have been violated. This encompasses the rights of the child. This, Your Honor, goes to show that there is an avenue to protect the victims once their rights have been redressed. And Your Honor, if I may, this is because of the state's resources, which are not, in fact, which as stated in paragraph 1, the state is a developing state, Your Honor. Therefore, the funds and the resources that we as a state hold are not very many, Your Honor. And we have utilized our resources to the best of our abilities, Your Honor. And that is why, thank you, Your Honor, for this opportunity. In furtherance of my on to my next point, Your Honor. It is our submission that the obligation to protect from trafficking was fulfilled additionally because the state has criminalized trafficking. And through criminalization of trafficking, this is why the applicants can even come here today to seek redress, because under Article 165, it states that the court has original criminal jurisdiction. Additionally, there is the enactment of the Anti-Human Trafficking Child Protection Unit, which is a child protection unit, Your Honor, that is dedicated to ensuring that child trafficking does not take place, Your Honor. Additionally, in the 2023 report on trafficking in persons, there are measures that have been highlighted that we as a state have fulfilled. These measures include partnering with various NGOs. Your Honor, the reason why we partner with various NGOs is due to the lack of resources in our country. Therefore, we partner with these NGOs to ensure that just because we are a developing state does not mean that our citizens should not be able to be protected. Additionally, Your Honor, there are funds that have been put in place to support victims of child trafficking. As per that report, the funds put in place by the state are 7.6 million. Consequently, Your Honor, we submit that the state has fulfilled its obligation to protect the rights of the child using all the measures that I have listed above. Yes, Your Honor.
You're talking about partnership with NGOs.
Yes, Your Honor.
Do you want to tell this court that the NGOs is running the government?
No, Your Honor. That would indeed be absurd, as that would not only undermine the sovereignty of the state, but it would indeed be very sad if that were to ever happen, Your Honor. Your Honor, these NGOs just come to support the state in the areas where the state feels is necessary, Your Honor.
With all the facilities that the government has,
yes,
you are not able to identify the violation against G, the minor. It is through the efforts of Amka Africa that this matter is before court.
Thank you, Your Honor, for your question. I shall submit on the same. The applicants have rightly pointed out that GW was confined to Rukia's house. Therefore, we as the state submit, we cannot go door to door asking who is your child or who have you subjected to child labor, Your Honor. And that is why, seeing this as a weakness in our state, we have enacted several measures to ensure that whenever such violations occur, there is a route to seek redress. And Your Honor, we do submit that we do not just want to give temporary redress. No, we want to properly investigate the crime that has occurred and ensure that all the perpetrators of this crime are held accountable, because we would have failed in our obligation to protect if we just went for the easy route and just filed a case in court and the case was denied simply because we did not want to appear before this court. Your Honor, we submit that, Your Honor, we seek this court to give us a few months in order to finalize our investigation, which are currently ongoing, as we are talking with Kilimobora on the same. However, in order to protect the integrity of our investigation, we will not like to submit on what the talks have held. Thank you, Your Honor.
Counsel, are you aware that this case is touching on a minor?
Yes, Your Honor.
And you are aware what the Constitution says about cases touching on minors?
Yes, Your Honor.
What does the Constitution say?
The Constitution says that in any case touching on a minor, the best interest of the minor shall be upheld. And Your Honor, our submission that it is not
other than the best interest of a minor, what else do you consider?
In the best interest of the minor, we consider survival. Sorry, Your Honor, please.
Other than that point of best interest of a minor should be taken at heart, what other thing would you consider?
The evolving capacities of the minor, Your Honor.
No, the matter should be disposed expeditiously.
Yes,
You're aware?
Yes, Your Honor.
You've taken, the state has taken 1 year to bring this case to court. You are asking the court to give you more time.
Yes, Your Honor.
To do what?
We are asking the state to give us more time in order to ensure that the best interest of the child is actually realized, Your Honor, because it would be an exercise in futility for us to present before this court and for the rights of the child not to be protected, Your Honor. We need to do our due diligence, Your Honor. Our prayer is that this court grants us another 4 months to finalize on the process that is already ongoing in order to ensure that this child's best interests are protected and everybody who was involved in subjecting this child to the various atrocities is held accountable.
May it please this court once again. 1 minute. I turn to reply. We've been given a plethora of laws and regulations, my lords and ladies. Allow me to rely again on the case of US versus France, as I stated for you here. In this case, the European Court found that it is not enough for the government to just pass laws. It is important that they take active measures in implementation. We were waiting to hear that they give us statistics. They tell us that we put this measure in place. From this measure, we achieved 1, 2, 3. They have not done that, my lords and ladies. We're waiting to hear that from this law, we've been able to achieve 1, 2, 3, my lords and ladies. Have we had that? I doubt it. My lords and ladies, allow me to further go back to international treaties and conventions in regards to state duty, state responsibility. Unless I was in my own world, my lords and ladies, the wording of all these conventions and treaties that state parties shall, not Amka Justice Initiative shall, not Kijani Kibichi Human Rights Commission shall. It is a duty that is imposed on the government. That duty cannot be disposed of onto NGOs, onto CBOs, onto CSOs, my lords and ladies. Where the government fails in that duty, then they cannot say that Amka Justice Initiative has done this for us. No, the government has simply failed. And notably, the respondents also noted that, claiming an excuse in regards to financial constraints. Absurd, my ladies. In that moment, allow me to rest again. And thank you for that question, my lord. You indeed raise a very important matter. And I hope that in answer, I'm able to clarify a lot to the entire court as well as individuals in the gallery. The European Court of Human Rights, the European Court of Human Rights forms part of comparative jurisprudence to our jurisprudence here in Kijani Kibichi, my lords and ladies. Beyond that, our jurisprudence allows for determinations from regional commissions and courts, and they are admitted to our courts as persuasive in nature, not binding, my lords and ladies. The case is cited in a persuasive nature, not a binding nature upon this court, my lords and ladies.
Is there domestic precedent?
Thank you for that question, my lady. I was limiting myself to issues that we had raised before, but allow me to cite several cases. We have the case of KKR versus Republic. This was a question of trafficking, where the court stated that where the child is underage, below the age of 18, it becomes irrelevant to show that deception was present for trafficking to be found present, my lords and ladies. Beyond that, we have the case of Mohammed Asif versus the Republic, which stated that where trafficking has occurred, everyone in the chain is complicit of trafficking, from the person who put that person on the bus, from the person who received that person, from the person who housed that person. All of them are complicit. In this instance, from the parents, my ladies and my lords, to Rukia, to Sony, to Rehema Recruitment Agency. Beyond that, we have the Republic versus Commissioner of Police and another. Here, it's clear that the police have a mandate to investigate all these proceedings. In relation to that, we have a court that was a decision, that was made in the commercial court at Milimani last by Justice Sifuna, where Justice Sifuna stated that investigations cannot go on forever, my lords and ladies. 1 year is forever.
So you have answered adequately. Just like to emphasize that general rules of international law are applicable in our laws, because the Constitution under Article 2.6 provides that any convention ratified by Kenya shall form part of our laws. And that is why you are able to quote those conventions, those international and regional conventions.
Thank you for your guidance, my lady.
trafficking in persons. I don't think you're familiar with that. Maybe if you peruse, you will find that what I am saying is in fact factual. Additionally, the applicants have alleged that I am misleading with a gross domestic product, and it has a growing population of about 50 million people. As rightly pointed out by the applicants, people from Kilimobora are constantly coming to Kijani Kibichi. This also depletes the resources that we have available. Your Honors, it is my submission that the resources in the state are not.
Council, you are opening a Pandora box. You are highlighting points that you had already submitted on.
Yes,
so leave it to us to rule on it. Yes. And the last one, from the petitioners, I expected you to highlight the recruitment agency. The government has failed to regulate that recruitment agency. It has given a license, and because of that, this agency is exploiting. So I expected you to give a punch on that. Thank you very much. We've had your submissions, and we are going to give a ruling on the same. The court is adjourned.
order of things actually is okay. So I have not told you his whereabouts, but I just told you his order of things. Are we good, judges? Okay. So then I can have Justice Nick and Justice Murray finishing up, then we go. Then the rest of the judges can continue. And then we'll have comments from the members of the plenary telling us what did you think of those arguments? Did they make sense? Do you think we are going to solve the issue of child labor, human trafficking, modern slavery? I was listening to someone arguing, and they described what Guyo went through. You know, the house, eating leftovers, and not being able to call, working, and I'm thinking, so I'm just waiting at that point and for him or her to just conclude and say, that is the definition of modern slavery. That is the definition of modern slavery. Where you work in a forced environment and you cannot come out. You cannot come out. Yes, that actually is what we call modern slavery. How many people in this country are in modern slavery, by the way? Think about it. I told you to open your mind when we started. We're still waiting for the judges to deliberate. I told you to open your mind when we started. When you think about the definition of modern slavery, think of the many people we have in modern slavery. Think of the many people who are getting trafficked for the purpose of doing that. I'm just giving my comments also. The other thing we're looking at is the ability to connect facts. In addition to yes, and the judge has mentioned that, there's that element that didn't come out very clearly among all the teams. The role of recruitment agencies. Without Sonia and her what is the name of that recruitment agency? They would not have, it would have been very difficult for Sonia to actually be able to get G from Kilimambora to Kijani Kibichi. So, what is the role of that recruitment agency there, and who registers? When you are actually looking at legal issues, you must learn to go beyond the letter. You must learn to go beyond the letter. Whereas we say we go beyond the letter to the spirit, okay? Now, in this case, the spirit is what? Who actually is in this chain? The bringing out of the number of the actors in this chain needed to come out clearly. And that didn't come out very clearly, especially the role of recruitment agencies. Especially people who get trafficked, whether it's domestic trafficking or external trafficking, outside transboundary trafficking. There is always, a lot of time, there is an agency involved. And so, that's why we must think of what is the role of this. Who actually gives them that platform? Who races them? Who penalizes them? Who monitors them? Who ensures if they misbehave, they are penalized? So we have to think along that. What about the role of relatives and parents in facilitating trafficking? That did not also come out clearly. You see, there is a reason the drafter of that question, by the way, who is a former student, graduated this year. That Moot question was drafted by a student who graduated this year. Unfortunately, he could not be here today. And he's part of the legal clinic, JQuat Legal Clinic. And I asked him, why is this business of parents of Guyo are being told the truth, but Guyo is being lied to? He said, I want to bring out the aspect of relatives' participation in facilitating trafficking. Okay. So, yeah, come and take over.
Thank you, Milka. So for those who do not know me, Claude is my name, Claude Kandem, from Amka, but also a proud alumni of this great institution. And yes, so the bench is ready to render. So the bench is ready, but as we've been told, there's some judges or some members of the bench who are going to be engaged in another activity before we carry on. So we want to So the
Okay, there is a slight issue with the program. The judges have confused us. In the program, we go away. Then you give your comments. Then you give.
yes. So Tony, everything is ready. Sound, lights, the camera lights. Yes. So we want to hear this story of Joan in the next few minutes, and after which we shall have the judges come back and we shall now close. Please, all teams who have participated, we appreciate your hard work, we appreciate your time, your commitment and energy in this process. So please do not be in a hurry to leave. There is something for everyone who has participated. I repeat, there is something for everyone who has participated. So please don't be in a hurry to leave. But for now, let's get to hear Joan's story. Tony, maybe you can test the sound.
Project on child labor. We are partnering with the Freedom Fund and many other partners in the country and outside the country to ensure that all children are removed from labor. Children should work, because most of the time we find people who say, oh, you don't want children to work, how will they become responsible human beings? Yes, children should work. But the question is, which children, what age, and the nature of work that they should do. So any work that affects a child's health, either physically, psychologically, emotionally, that is not good work. They should not be doing that work. Or any work that removes a child from school. Now they have to stop working, leave their home and go work in a third party's home. That is not good work. Any work that makes a child stop being a child and become an adult, in the sense that they're not able to enjoy what normal children are doing. Normal children are going to school, also enjoying, even after they have done some work at home or wherever place they are helping with work, they have time to play and have some leisure work. But when you engage a child full-time in an employment like an adult, they don't play, and their health is affected and they don't go to school, then that is what we call exploitative child labor, and that's what we're trying to stop.
Nilikuwa naishi na sister mamangu. Nilikuwa bado sijapelekwa shule. Then sister wangu akapiga simu, akasema tena nitaka niende nisome Nairobi. Nikakataa, sitaki kwenda Nairobi. Sister mamangu akaanza kuniambia, "Hautaki kwenda Nairobi na unataka kukaa hapa na nani?" Sasa akatuma pesa, nikaenda. So kufika huko, sister wangu siku ya kwanza tulikuwa tu vizuri. Ya pili, so nikamwambia ati sisi mimi nataka kwenda shule. Kaniambia tu nataka kwenda shule na mimi niko na mtoto mwenye nafundisha, nataka nilipe rent. Wewe uko na mamako, sienda kufundisha. Kamwambia ni sawa, kama si wewe ulisema ati nikuje huku nipeleke shule, basi ungeniacha nikae huko na mamangu. Kaanza kuniambia tiacha kunipigia kelele, ukitaka toka ende uko chokora kwa street.
Akakaa kwa dada yake hiyo, akanipigia simu, huyu Joan anatembea mbaya sana. Sasa nifanya namna gani dadi? Nimesema mbeleza kidogo tu, mpike su, ametoka Uganda, amekuja kwako. Mbeleza aende kwa shule, tutaona baadaye.
So hadi mimi nikatoka, nikaenda kwa mama mwingine hapo Maroroi, hapo ndo pale nilikuwa sana nafanya kazi. Tukatoka Maroroi tukaenda Kariobangi.
Sasa nikatuma Flo dada yake, enda angalia kama yuko huko. Akasema ameenda Kiambu, akapata huyo mama amehama, amekosa na bwana yake, ameenda na huko. Sasa mimi sijui pala nenda. Sasa utafanya namna gani?
Asubuhi nilikuwa naamka saa 11 na naosha vyombo, napikia mtoto chai, then naamsha mtoto ikifika saa 12, naamsha mtoto mwenye alikuwa class 1. Sasa nikisha namvalisha, kishamvalisha nampeleka shule, then narudi ndo naanza kufua, kupiga dasta. Nikimaliza napika lunch nampelekea saa 6. Alafu nikimaliza nakaa tu sasa. Alikuwa tu akitoka akienda job, saa zingine ameacha chai pekee na hajakorogea mtoto uji. Sasa namwambianga sasa, unaacha mtoto njaa na mimi naweza kaa njaa na mtoto hawezi kuwa njaa. Kwanza kuniambianga, kwani mtoto ni wako, mtoto ni wangu. Mimi ndio najua. Mimi nikamwambia ni sawa, kama mtoto ni wako ni sawa tu. Mimi nikaachana na yeye, nikaenda kwa mama mwingine hapo jirani, nikakaa huko. Akirudi jioni, alikuwa anarudi saa 3, ndio sasa anashughulikia mtoto wake. Sasa mimi nikanga nakula kwa jirani. Nilikuwa nakula tu once time yenye hajaacha food. Manguo nilikuwa nafua asubuhi mpaka kitu saa 8. Saa zingine simalize. Akipata kazi sijamaliza ananiuliza ati mbona hukumaliza? Kamwambia ati kichwa ilikuwa inaniuma. Niambia kichwa ilikuwa inakuuma tamini, ulikuwa unakuja kutafuta kazi. Huko unajua kama kichwa itakuja kuuma. So nikanyamaza. Akaniambia ende uzifue. Nilikuwa kitu saa 4. Nikaenda tu hadi mimi nikafua. Nikamaliza.
Nikakaa muda. Sasa nitaanzia wapi? Mama yake alienda Uganda, pale nyumba yake ni. Sana fanya namna gani?
Nilikuwa tu kazi zangu ilikuwa tu kuosha manguo, kupiga dasta na kupanguza na madinisha pekee. Kupika pia. Kulala nilikuwa nalala saa zingine saa 3 ama saa 4. Tulikuwa tumekubaliana na yeye ikifika Januari anipe pesa yangu narudi shule. Aliniambia mwezi kiisha ananilipa 6,000. Sasa ilikuwa mwezi kiisha nikimwambia atanipe pesa ananiambia ati baada hajapata. Sasa mimi nakuja na akati tunanyamaza. Siku nyingine pia nikamwambia ati sister yangu anasema ati anataka nirudi shule. Na anataka niende kwa mamangu. Sasa unipe pesa niende. Kaniambia ati ongojea. Sasa nikaongojea tu Januari bado niko tu kwake. Akataka kunilipa pesa. Sasa ndio hawa majirani wakacheka tu.
Ikifikia karibu mwezi 2-3 hivi watu wamekuja hapa asubuhi saa 2 asubuhi. Nilikuwa kwa shamba hapa. Nimekuja Kenyasa. Nasema pale. Nilipata sub chief na chief. Na Duncan Moot. Nasema wako gani? Nilipata kama chief anakuja hivi. Sub chief iko pale na huyo kijana alikuwa kijana huyo ito nani?
Kwa majina ni Joseph Ofula. Mimi ni community based paralegal, community health promoter na children's protection volunteer pale Kariobangi North. So kesi ya Joan nilikama across through village elder. Village elders wanakanga pia kwa committee za chiefs. So in case chiefs apate kesi anajuanga watu wa kumsaidia because si kila kitu ana handle. So pale kwa kampi ya chiefs tuko na ofisi ya tuko na children's office mahali C2K. Chief pia kuna ofisi yake. So hiyo kesi ilifika kwa ofisi ya chief through the village elder akarifa pande yetu. So pande yetu tukafanya follow ups.
Nilikuwa tu kwenye nilikuwa namwambia nipe pesa. Akaniambia sitakulipa, ukitaka enda kwa polisi. Kamwambia mimi sina time ya kwenda kwa polisi. Na kama kwa polisi ndio unataka naweza enda. Kanyamaza. Hiyo siku ikapita hivyo. Na siku nyingine asubuhi. Kamwambia usinipe pesa, mimi nataka kuisha kwetu. Kaniambia kwenyu, nataka kuisha kwenu. Sitakupatia pesa. Ati hapana, acha tu siende shule. Ati naweza kufundisha saluni, ujue kushuka. Nikamwambia mimi sitaki, mimi nataka kwenda bado kusoma. Yeye mwenyewe siku nyingine akarudi, nikamwambia nataka pesa. Sasa ilikuwa usiku, baada huko amepika sapa. Kumwambia kaanza nataka kupigana na mimi. Sasa vile alinipiga, tukasukumana na yeye hivyo. Sasa hiyo siku usiku ndio time tulienda kwa sijui alikuwa chief mwingine hapo. Ndio tukaenda kwa hiyo chief. na tukaenda kwa polisi.
The good thing is that tulipata the first-hand information from the child herself na the community wenye walikuwa around mali alikuwa ameajiriwa. So baada ya kusikia kesi, number 1 tuliripoti kwa police station Kariobangi, then tuka-inform children's officer wa Kasarani.
When we talk about Kasarani sub-count, that's we mean Ruaraka, Kasarani itself and Roysambu. Okay, we received a case of Joan late last year, 2022, November. The case was reported to us by our child protection volunteer within Kariobangi location. It was a case of child labor. We referred the case to police station, that is Kariobangi police station. We write a referral letter to Kariobangi telling them to manage the case in the best interest of the child.
Already stake ya mtoto mwenyewe ako at stake, hawezi rudi mahali alikuwa ameajiriwa. So waliandika barua za kumpeleka ama kutafuta shelter. So shelter ilikuwa karibu, inaitwa Tree House. Huko ndio barua zilitoka kwa children's office na police station. Tuka take the initiative, tukampeleka kwa shelter.
Vile waliorganize na wale wa polisi, akawaambia siku yenye ataleta pesa. Niambia nitaleta siku hii, nitaleta pesa. Sasa mimi nikaenda, nikatolewa hapo kwa polisi, nikapelekwa children's home. Sasa nilikuwa naishi huko children's home na Ankonika.
Jambo la kwanza tulielezewa na children officer mali alikuwa child labor na kulikuwa na cases hapo around. So kitu ya kwanza tuliongea na huyo children officer kwa nini wanaomba mtoto tukae naye.
The child looks, at that time we assessed the child was somehow dramatized and he looked very quiet. The child was not even free to talk with us, and we decided to refer the child for counseling, and that's why we did a placement in one of the CCI within Lakisama.
Ili tubidi tuanze kufuatilia kwa nini aungani na wenzake. So turu hivyo vile tulipata kama ako na mawazo nyingi, ilibidi tuanze mambo na counseling. Juu alikuwa na mambo mengi na msumbua venye anaweza pata watu wao, arudi kwa mama na ilikuwa mbali. So hii ilifanya kwe anajitenga sana.
Challenge number 1 ilikuwa ule alikuwa mtoto msichana. Mali alikuwa ameajiriwa kwa anajua mtu yote because wao mwenye alikuwa mwajiri hata kwa relative. So alikuwa number 1 kwenye siku zake za hedhi. So ana nguo za kubadilisha, hawezi rudi kwa household yenye alikuwa, unaona. Then number 2 alikuwa anahitaji kitu kama food, maji. Then mali anaweza badilisha mavazi pia ama mali ya kuoga, unaona. Na kama mtu mwenye deal na story za watoto, hauwezi mpeleka nyumbani kwako. So hiyo ilikuwa challenge kubwa sana.
The main problem is when we need to rescue a girl and place them somewhere as the matter is ongoing. In most cases, these are girls who are 15 years and above. So sometimes you have the challenge of where to place them as the matter is ongoing. When they come from far counties, far from Nairobi, we are not able to provide the services that we would wish in terms of taking them back to their families.
Mwanzo alikuwa na uoga, hakukuwa naelewa kwa nini alikuja hapa, lakini ni sisi tulimuelezea sababu wale walimuokoa, walimtoa tu kwa sine, lakini hawakumuelezea maelezo ya chini. Sasa wakati tulikuwa hapa, ilibidi tumuulize, sisi wenyewe tulimuuliza kama alikuwa anaenda shule nini, ndio tukafanya kumueleza kwa nini yako hapa. Tukamwambia hapa ni rescue center na umeletwa sababu ya ina hii.
So police station lazima challenges zikue. So wakati tulienda kuripoti pale police station, utapata like polisi wako overwhelmed, unajua, because kesi mingi zenye wanasikiza pia au like zina affect mentally.
We tried to ask the police to have the perpetrator in custody, which was not possible as the police claimed the perpetrator escaped. And later they told us the perpetrator, in fact, he shifted from his initial residence and was not traced.
So kulikuwa na, this was an urgent issue enye the police ama ule polisi mwenye alikuwa pale kwa gender desk alikuwa shughulikie because ni urgent, unaona. Hakuna funds, hakuna mahali mtoto anaweza kaa, unaona. Shelter pia afai huko for long because akona kwao, unaona. Then pia usi kama wanajisustain, so ilikuwa ngumu kidogo, wana work with limited number ya watoto wale wenye wako pale kwa shelter. So askari like alikuwa na take his time afanye investigation, unaona. So like ilikuwa pressure kwake because pia si tulikuwa tunampush.
With the help of the Child Protection Volunteer, the CPV, and the police, the chief's area and the Nyumba Kumi, they helped us reach through phone communication with the perpetrator, who later, we are told, she paid the arrears of the child as a pay for employing the child in their house.
Vitu mwanzo zile tunaitisha, kwanza tunataka kesi tupate kesi kutoka kwa children officer, barua yao, tukue na OB, alafu tukue na ule children officer ule anafuatilia kesi yake venye kunaenda. Zile vitu kama saa zingine challenge, ndio maana sijaendelea sana. Watu kama wamekuwa abandon ama hizo kesi wanafanya hivi, ni vigumu kupata kwanza birth certificate yake. Juu mtu alitoka hapa, hajatoka kwao, ana birth, unaona. So hata tukitisha children officer wasema hawezi pata, tunaomba tu nafasi ya kukaa kidogo tufuate kesi yake. So kesi yake ni barua ya children officer na OB kwa imejulikana na kwa polisi, kuna mtoto tumekaa nayo na children officer wamekubali. Au tu ndio tunachukua kwa hiyo kesi, juu wao tunakaa short period, lakini wale tunakaa nao muda ndio tunatafuta hizo vitu zingine.
The placement was temporarily, and the reason of placement was counseling, and meantime as we were trying to look for family, we were trying to do family tracing for reintegration. So we, with the help of Tree of Life, with the help of the chief, we talked with the child, who revealed his initial home to be in Unguja, where then we looked for contacts of the chief through the children's office in Unguja, where they helped us have the contact of the parents. Then we started planning for post-sport integration.
Nilipata report kutoka Nairobi kwa umoja wao. Sasa before akuje nikaangalia, wameniambia ni trace penye kwa kina Joan wako. Wakaniambia, wakanipa direction. Sasa nikampigia chief wa huko, nikaongea nayo. Chief akaongea na CPV ya huko, then akampigia village elder. Sasa mimi pia nikatoka hapa nikaenda huko kwa chief wenyewe.
Nilipata simu kutoka kwa bwana Wafula. Jaka nipigia simu ati kuna mtoto ambaye amejitambua ati anatoka area hii. Sasa kwa sababu sasa jina ilikuwa kidogo sikuwa naifahamu vizuri, nikajaribu nikaongea na wazee wa mtaa. Nikaambiwa kweli jina kama hilo liko area hii. Alafu sasa tukaorganize, akasema akaniambia alikuwa na masaibu kiasi, alikuwa kwa children's home somewhere. Then we organized vile, alafu tukaongea vile anaweza fika huko.
Nilipata report kutoka Nairobi kwa umoja wao. Akanipigia simu akaniambia siku fulani anakuja na Joan. Sasa before akuje nikaangalia, wameniambia ni trace penye kwa kina Joan wako. wakaniambia, wakanipa direction. Sasa nikampigia chief wa huko, nikaongea nayo. Chief akaongea na CPV ya huko, then akampigia village elder. Sasa mimi pia nikatoka hapa nikaenda huko kwa chief wenyewe. Tukatoka na chief tukaenda kwa hiyo boma. Tukaongea nao, tukawelewana. Sasa siku ile nikarudi, siku ile ambao mlikuja nikapata kama nishajua kwa kina Joan. Sasa tukatoka hapa tukaenda kwa kina Joan, nikampigia chief pia akaja huko.
Nilipata taarifa kutoka kwa chifu wangu ati kuna mtoto ambaye inasemekana anatoka hapa kwetu. So vile alipigia mzee wa mtaa simu, na sisi tukatoka moja kwa moja tukaja tukaenda mpaka hapo. Tukaongea, tukapata afisa wa idara ya watoto wa Ugunja. Akatupigia, tukaja hapo tukapata tayari huyu mtoto ambaye anaitwa Joan alikuwa ameshafika wakiwa na bwana Wafula na hiyo foundation ambayo inajiita Amka.
Before tufike kwa hiyo kijiji tulieleza kwanza chief, tulimwambia tukienda, na vile tulifika tukampigia, akatuelekeza, akatupeleka mpaka kwa boma. Kufika kwa boma hatukupata mtu, baba yake hakuwa na mtu yote. So chief akatafuta wazee wa kijiji wa hiyo area. Kwa hizo EPAP za kuangalia mali maybe wazazi wanaweza kuwa, wakapatana na baba yake. Baba yake alikuwa amestuka.
Chief naita mimi. Morris, kuja tu, usijali. Hakuna makosa mengine mbaya. Kuja tu. Nikikuja hivi, nikafika simama hapa, nikafika naona huyu mtoto na hao vijana huyo na mama mwingine kutoka huko.
Then wakaongea the native language ya huko. Wakamwambia hakuna shida, wakamleta, tukakaa naye chini, tukamuelezea vile situation ilikuwa, that mtoto alikuwa at risk, hakuwa anaenda shule na ni msichana, ako Nairobi, hana mtu yote mwenye anajua. Tukamuelezea the risk zenye alikuwa amewekea mtoto.
Tulifika na tulikuwa pamoja na chifu wangu bwana Johannes, tulikuwa na bwana Wafula, na tulikuwa na afisa wa watoto wa Ugunja sub county ambayo tulikuja naye moja kwa moja mpaka hapa.
Tumeongea na familia zao, tukamwambia Joan tumerudisha, warudishe shule kwa sababu bado ni mdogo. Wakakubali kupeleka shule.
Okay, shida kubwa kabisa tulipata, unajua mama alikuwa ameseparate na baba. Sasa katika hilo harakati, unajua sasa kuna mtu anachukua kitu kinaitwa parental responsibility. So mtoto alikuwa sasa ni kama anahangaika. Unajua saa zingine ujumbe saa zingine atufikii kwa ofisi. Sasa mtoto pia alijikuta kako Nairobi. So vile alikuja wazazi kiwajua sasa kwa kawaida kama kuna shida nyumbani, mama anarushi, mama anasema shida ilikuwa baba pia anasema shida ilikuwa mama. Sasa alafu toka hapo tukaongea, tukaambiwa umuhimu ya kitu inaitwa that parental obligation. Sasa tukaambia kitu ambayo inaitwa the Children's Act inataka haki ya mtoto vile inatakana ikue. So tukawazungumza na hawa, tukaambia kuna part of it ambayo is a very akani kisheria is a criminal. Kuacha tu mtoto anatembea hivyo hiyo anaweza shtakiwa. So tukaongea, nikaona kama tukapam karibu ka sense kidogo kwa kichwa.
Sasa wakifika hapa nasema sawa, huyu ni baba yake, mimi ni baba yake. Alitoka hapa kama class 3. Sasa wakaandika maneno wakasema huyu ni Joan mtoto yako. Sasa huyu ndio. Sasa welcome. Pita nyumbani, welcome. Nyumbani kwa tukao mzuri, tuongee tuone matoto maneno ile iko tu usome.
Nilikuwa na umoja wa Amka African na tulikuwa na chief na assistant chief na village elder, tulikuwa na watu wa kijiji pia kama familia yao, ndugu yake, babake na stepmother na majirani zao pia au watu wa community hapo.
Tukapeana namba ya Amka Africa, tukapeana namba ya chief na children's office. Yeah. So kama kuna issue, mtoto hataki kwenda shule maybe, of which haikuwa case, mtoto alikuwa so passionate about education. So ilikuwa tu in case wanahitaji kitu yote, so wanaweza pigia Amka Africa ama chief ama children's office.
Kila mtoto ako na haki awe kwenye shule. Sasa vile kesho yake asubuhi nitoka moja kwa moja mpaka kwa hiyo boma ya mzee, nikamchukua huyo mtoto Tukaja naye mpaka kwa shule ya msingi. Tukakuja hapo pamoja na mzazi, nikaongea na mwalimu mkuu, akakubali kwamba atamchukua arudi kwenye darasa. Ningependa sana kulishia mwalimu mkuu shukrani kwa sababu walimchukua because yeye alikuwa anafanya ile system ya 844 na kitambo kidogo hiyo system kama ilikuwa imeisha. Hii the class 8 ya hii ndio ya mwisho. Sasa mwalimu alijaribu kumchukua akamtoa from class 6 ya kitambo mpaka class 8. Na we are very happy saizi mtoto anafanya vizuri, ako average katika hiyo class.
Mara mingi kama serikali tumejaribu kufanya kusensitize. Tumejaribu kusensitize kabisa, and also tumejaribu pia kuchukua action. Kwa sababu unaona kama sasa kama ya Joan, just hiyo ni project yetu sasa. Even the whole that area, they just know how, when they saw the whole team coming from Nairobi, the whole story, how the Amka Africa did, now they think that at least the government is very serious about these issues. Because you see in Abaraza, when you talk about those issues and you also give some, it gives some deterrence.
Shida iko kwa sababu ni hanga, mambo ya chakula ndio inaleta wazazi wanachukua watoto wakiwa wadogo. Sana sana watoto watima. Ndio sasa inafanywa wazazi wanamchukua, wanampeleka kufanya kazi ndio afadhali wapate kitu ambao wanaweza kulisha nao wengine. Lakini tushajaribu kuongea na watu kijiji, tumeenda kwa barasas, tumeenda churches tukaongea. Sasa safari tumewambia wazazi watoto, tukipata watoto wa maina wakienda kufanya kazi tutawashika wazazi, si watoto.
Kesi za watoto kulingana na hii eneo tuko ni nyingi sana, sababu setup ya community au mambo yanafanyika sana. Sasa mambo ya kutumia watoto, kuweka watoto wafanye kazi kama umri wao haijafika ni mengi sana sababu ya issue na kifamilia. So kesi ziko nyingi, hata zingine zina manage kukua successful, ukuje upate wazazi wakubali warudishe mtoto shule, zingine zinakataa. So kesi ni nyingi sana.
Kazi yangu watoto wenyewe kwanza ndio wao nieleza, manake tunafanya mentorship kwa shule, then tunaorganize community events. So kesi kama hizi mingi ziu tukujia, manake number one watu pia wanaogopa kwenda kwa police station, wanaogopa kwenda kwa chief. So wanajua that nikitarget Joseph hii mambo itapata suluhisho. So mingi zinakuja, tunapeleka, inakuwa tu maybe ni wazazi wako wameelewa. So tunawakalisha chini, tunafanya mediation kidogo, then after hapo tunawarudisha nyumbani kwao, then tunaendelea kufanya follow up na mambo inarudi inakuwa mzuri.
We have also made a system, tunajaribu kuongea na walimu sana, especially walimu wa shule. Unajua sasa hao walimu wa shule ndio wako na register. Saa zingine mzazi hataki kujua. So at times tunaenda kwa shule, nauliza watoto wanakuja shule wote, nasema shule iko sawa. Saa zingine kama kuna msichana ama kuna mtoto ama mtu yote ambaye kuji shule kwa muda chronic absenteeism, tunaangalia tunasema labda kunaweza kuwa nini. So that tunadua follow up. Unajua village ndio catchment area watoto sana. So most cases tuna coordinate na walimu. Tukisha coordinate na walimu, alafu tunajua kina nani hawako na kwa nini hawako. Saa zingine unaweza kaa kama serikali nafikiri watoto wako shule na kumbe hawako shule.
I would speak from the child protection perspective that I'm from the Directorate of Children's Services, and we know that children need to be in school at some point. So when we have a 15-year, 16-year-old girl doing domestic work, it means something somewhere is not right, because at that age they need to be in school, either in primary if they didn't start as early enough, or in high school. So I would not be agreeing with that school of thought where we are saying that they need to be working at that age, and it does not help in their developmental capacity to be working at that age. I know if we are saying, I would look at the child labor, the act that allows children to work from 16, 17, but that is in terms of getting to practice what they have learned about. So we cannot say domestic work is something someone has learned and they need to practice at that age.
Nimeshukuru sana. Wajua serikali mara mingi huwa na advocate yenye inaitwa multi-agency approach in service delivery, whereby the agencies, several agencies work together to ensure that the citizens wanakuwa served. That's what the government has really advocated for. Na sasa unaona kama Amka Africa is very structured the way it acts. You see, when you partner with the government, now it makes work so easy because now there's coordination. You see, coordination is just like a cobweb. Because the people that we have at interest ni watoto. So it doesn't matter who is nani anafanya kazi gani, lakini at the end of it all nataka mtoto apate haki yake, mtoto aendelee sawasawa.
Hata Amka African Kenya pia tumeomba siku nyingine pia mtuletee hiyo
in future. Thank you very much.
Thank you for this opportunity. I've never been to such a platform, but I'm so glad. Both the team were good, but we must have a winning one. For the ladies, I saw they responded so well.
Question, eh? You are a survivor of human trafficking. Did you think that you would hire any of them for your case? Did you think they are enough?
Yes, they are.
You would hire? Why?
Because they are doing a great job for me on my side.
So you heard that the issues were coming out as you'd like them to come
Yes.
out? Okay.
Hi, I absolutely differ and confer with the local judges and all your expertise, and you've taught me a lot just sitting here today. Thank you. I really appreciate it. Also in how you challenged taught me so much. So I've seen that significant change can happen through the courts, and I live with the change that happens through the courts, so I'm so grateful you're doing this because courts can make a huge difference and change of law. and holding people accountable and holding governments accountable. What I didn't see was specificity in the ask and specificity and going bolder, right? Like you could ask for compensation for what the future could have been for G if she had been educated. Compensation for, well, did you sue the state? Did you sue the traffickers? And what did you get with that compensation? How can that compensation best serve G? Like compensation for, her damages emotionally and physically. And that government won't learn unless you punish government financially and significantly. It will continue to do this. So I think you could have had more specificity in the ask and older, because it's like a negotiation, you know, then they have to push back.
Okay, I think I just wish to add to what she has said in terms of the prayers. I think we struggle a lot trying to get you to tell the court what orders do you want the court to give that you can implement. Now, in framing your orders, I think the strategy is, for this kind of cases, you're going to have orders which have long-term effect. Like now when you're asking for policy put in place, certain measures to be put in place. But now remember, there is an individual who is currently in a situation. So what can we do for this particular individual in the current situation? So there'll be two sets of orders, those specific orders to address a specific need, and then the general orders. So for specific need, for example, this child needs to be in school. We cannot wait until the day policies will be made for this child to go to school. So there is immediate order to be made that this child be taken to a certain school, and the government to cater for the costs for that child in that particular school. There is the issue of compensation, financial needs for that child. So you address those needs, you ask the court to order that those needs be met with immediate effect. Then you can also now ask for that certain policies be put in place over time.
Thank you, fellow judges, for that insightful observation. Participants, I like what Wahu said in the beginning, that do not focus on the legalese. This is a crime that affects us in the society. It is a transnational organized crime. If you look at the case study, the mother was even convinced that the child is going to get money. So we needed to, the evidence is scattered all over. The evidence is scattered in one state, and there's also some evidence in another state. So what we are telling the court, that even what the court will do, it will even impact the mother of Guyo, who is in the village. The mother of Guyo will understand and appreciate why young girls should not go for work, but study. How will they appreciate? By the government, by the court ordering the government to have this child in school and be educated at the government's expense. So by just touching on this case, in this state of, is it Kijani Kibichi, without letting the people in this other state, what is the state again? Kilimabora, know. It has to be known in both states, the impact, what has been done. And then the aggravating circumstances. You see, this girl suffered a lot. Being burnt using an iron box, it's so painful. And when you are submitting to court, tell the court what kind of pain and suffering this girl went through. And that will justify the amount that's supposed to be awarded. Okay? And that also explains on the exploitation. And again, this kind of offense, this is not just affecting this girl. It's something that, it is a scar that will follow her, even in her old age. It was something that she has just suffered and it will go away. It is something that will follow her to her old age. That is why you should bring out the aggravating circumstances. Again, the appellants, they failed to give a punch. Their points were scattered. They had points, but they failed to give a punch so that the court feels this is the real thing they really need to get. Again, you see the coordination of these suspects, Sony, Rukia, they are coordinated. They are coordinated and they collaborate. It actually exposed the government. The government is sleeping, okay? So it is time the government wakes up and also collaborate and come together with other agencies, partnership with like Amka Kenya, to ensure that these offenses are prevented. Again, I saw the state. They were so persuasive, you know, but they're persuading us that we give them time. You know, it's like the court trying to help them to commit more crime. So they are so persuasive, but what they were asking was illegal. The court cannot grant that. What I noted again, confidence in both teams. I appreciate your confidence. You maintain eye contact, and you also, you are thinking on your feet. She threw a question on why you're using European cases, and she was able to demonstrate why and explain. You're also maintaining eye contact. That was very good. So both teams won when it comes to presentation and persuasion. But like me being the prosecutor, I know the case. The winners would be the petitioners. Thank you. You already announced? Yeah. So the winners are the petitioners in the final. Their team what? What were the team names? Yeah? Team 05. So team 05.